Good morning once again. I request all dignitaries, delegates to please occupy their seats in the hall. Our chief guest has already arrived. He is here at the venue and is waiting for you all to take your seats in the hall. Thank you so much. I request all delegates to please come into the hall and take their seats. I also request you to put your mobiles on silent mode. Thank you. Hello. I repeat my announcement. All delegates, please take your seats inside the hall. Please put your phones on silent mode so that there's no disruption in the inaugural session. Thank you. यहाँ कलर चेंज मत कीजिए यहाँ नॉर्मल ग्रीन लाइट नो Our chief guest and guest of honor is already here at the venue. I request all delegates to please come inside the hall. You stand by here only so that, or if you want, you can take the mic and stand there. If you don't want to come to the podium. Then it's okay. Because मैं take. Godless one. Hello. please come inside the hall. There's a kind of sound. Ending में there's some kind of a humming note coming at the end. Humming आ रहा है बाद में? नहीं, बात ठीक है? यहाँ सुनाई दे रहा है. Okay, thank you. May I please request once again all dignitaries outside the hall to occupy their seats inside the hall. Thank you. We'll start from Chief Justice. Then, अच्छा, पहले उनसे फिर reverse. 1, 2, 3, 4. Okay. All guests waiting outside the hall may please come inside the hall and take their seats. Thank you.
Hello, 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 hello. Hello.
Good morning to all. I would like to invite our Master of Ceremony to start the session. Please.
Thank you, sir. Namaskar, Jai Jagannath. May I have the privilege to welcome this element gathering to Gyan Setu, a two-day national tax conference organized by Tax Bar Association ROURKELA with All India Federation of Tax Practitioners Eastern Zone. I sincerely welcome His Lordship, Chief Justice, Orissa High Court, Shri Shubhashish Talapatra, His Lordship, Honorable Justice, Orissa High Court, Shri Chittaranjan Das, and all special invitees. Without further ado, may I humbly request our dignitaries to grace the dais. I feel privileged to invite our chief guest, His Lordship, Honorable Chief Justice Subhashish Talapatra, to adorn the dais. His Lordship is to be escorted by Advocate Naresh Kumar Agrawal. Thank you, sir. Thank you so much, sir. May I now humbly request our guest of honor, His Lordship, Honorable Justice Chittaranjan Das, Orissa High Court, to please grace the dais. Advocate Vikas Rathi may escort Honorable Justice. Thank you so much, sir. I cordially invite AIFTP East Zone Chairman, Advocate Basudev Chatterjee, to grace the dais. Advocate Padmanabha Bisi to please escort, sir. Please escort, sir. Thank you. I cordially invite AIFTP President, Advocate Pankaj Ghia, to come on dais. Advocate Pradipta Kumar Rao to please escort, sir. I invite Conference Chairman Advocate Subhash Chandra Agrawal on dais to be escorted by Advocate Gudakesh Singh. I now invite ROURKELA Tax Bar Association President Advocate Ramakrishna Mishra to please come on stage. Advocate Pardeep Kumar Yadav to please escort, sir. Thank you so much. We shall now welcome our dignitaries on dais with bouquets. I request Advocate Dilip Kumar Agarwal to present a bouquet to Honorable Chief Justice Orissa High Court Shri Shubhashish Talapatra. Advocate Dilip Kumar Agarwal. Thank you. I request Advocate Diti Krishna Pradhan to present a bouquet to Honorable Justice Orissa High Court Shri Chittaranjan Das. Thank you, sir. I call upon Advocate Manoj Agarwal to please present a bouquet to AIFTP President Advocate Pankaj Ghia. Thank you, sir. I request Advocate Pitambar Panigrahi to present a bouquet to AIFTP East Zonal Chairman Advocate Basudev Chatterjee. Thank you, sir. I call upon Advocate Dilip Kumar Singh to present a bouquet to RTBA President Advocate Ramakrishna Mishra. Thank you, sir. Last but not least, I request Advocate Surendra Prajapati to present a bouquet to Conference Chairman Advocate Subhash Chandra Agarwal. Thank you so much, sir. May I now request this august gathering to please rise for the national anthem.
मन अधिनायक जय हे भारत भाग्य विधाता। पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा। विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा। तव शुभ नामे जागे तव शुभ आशीष मांगे। गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता। जय हे जय हे जय हे जय 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 हे।
Thank you so much. To commemorate this special occasion, may I invite His Lordship, Honorable Chief Guest, Chief Justice Shri Subhashish Talapatra, Guest of Honor, Honorable Justice Shri Chittaranjan Das, AIFTP President Advocate Pankaj Ghia, AIFTP East Zonal Chairman Advocate Basudev Chatterjee, RTPA President Advocate Ramakrishna Mishra, and Conference Chairman Advocate Subhash Chandra Agarwal to please light the ceremonial lamp amidst chanting of mantras by students of Vedya's Gurukul. Please, sirs.
अग्ने मीळे पुरोहितं यज्ञस्य देवं ऋतुजम् होतारं रत्नधातमम्। ॐ विश्वानि देवासवितर्दोरिता निपरासुवा। यद्भद्रं तन्नासुवा। हिरण्यगर्भः समवर्तताग्रे भूतस्य जाता पतिरेकासेत्। सदा धार पृथिवीं द्यामुतेमं कस्मै देव यः विसाभिदेमा। यात्मदा बलदा यस्य विश्व उपास्यते प्रसिसं यस्य देवाः। यस्य छाया अमृतं यस्य मृत्यो कस्मै देव यः विसाभिदेमा। यः प्राणतो निमिषतो महित्वा एकैद्राज जगतो बभूव। यैसे अस्य द्विपदतोस्पदः कस्मै देव यः विसाभिदेमा। ये नद्योः रुग्रः पृथिवी च दृढः येन स्वस्तवितं येन नाकः। यो अन्तरिक्षे अजसो विमानः कस्मै देव यः विसाभिदेमा। प्रजापते न त्वदेता नन्यो विश्वा जाता निपरिता बभूव। यत्कामस्ते जोहोमस्तन्नो अस्तु वयं श्यामपथयो रयेणाम्। सानो बन्धो जनिता सविविधाता धाम निवेद भुवन निविश्वा। यत्र देवा अमृतमानसान स्त्रिते येधाः मन्नधे रयन्ता अग्नेनाय सुपथाराय अस्मान् विश्वानिदे भवयुना निविद्वान् यो यो ध्यस्मत् जोहोरान् नमेनो भोष्टान्ते नाम उक्तिं विधेमा.
Thank you so much. I now request President of RTBA, Advocate Ramakrishna Mishra sir, to please give a brief introduction of RTBA.
Good morning to all the dignitaries, guests and delegates present here today. A very good morning. I am honored to welcome you all to the two-day National Tax Conference organized by the ROURKELA Tax Bar Association in association with the All India Federation of Tax Practitioners at Hotel Pahadi, ROURKELA on 26th and 27th of August 2023. The theme of this conference is Gyan Setu, which means breeze of knowledge. The conference aims to provide a platform for sharing and exchanging ideas, experiences, and insights on various aspects of taxation law and practice in India. I am honored and delighted to address you all as the President of ROURKELA Tax Bar Association, a professional body of the tax practitioners in ROURKELA. I thank you for your presence and participation in this two-day conference. We are privileged to have with us today as our chief guest, my Lordship, Honorable Justice Subhasis Talpatra, the Chief Justice of Odisha High Court. He is a distinguished jurist and renowned expert in taxation law. He has delivered several landmark judgments on various issues pertaining to income tax, GST, customs, excise, and service taxes. We are grateful to him for gracing this occasion with this august presence. We are also delighted to have with us today as our guest of honor, my Lord, Honorable Justice Chittaranjan Das, Judge of Odisha High Court. He is an eminent lawyer and respected authority in taxation law. He has also contributed to the development of taxation law and policy by participating in various committees and commissions. We are thankful to him for sparing his valuable time to join with us. We are also honored to have with us today as our special guest, Mr. Pankaj Ghia, the National President of AFTP. He is a senior advocate practicing at Jaipur. He is a leading tax practitioner and a prominent leader of the tax fraternity in India. He has authored several books and articles on GST and other tax matters. He has been actively involved in the activities and initiatives of AFTP for more than 2 decades. He has represented the AFTP before various forums and authorities on matters concerning the welfare and interests of the tax professionals and taxpayers. He has also played a key role in organizing several national and international conferences on taxation under the banner of AFTP. We are obliged to him for his constant support and guidance to ROURKELA Tax Bar Association. We are also happy to welcome all the print media and electronic media representatives who have come here to cover this event. We appreciate your efforts in spreading awareness and information about taxation among the public. Last but not the least, we are pleased to welcome all the delegates who have come from different parts of the country to attend this conference. We hope that you will find this conference useful and enriching. We are hopeful that you will enjoy your stay in ROURKELA, where exists the first integrated steel plant of Asia. ROURKELA is also famous for its scenic beauty, cultural diversity, and historical significance. Presently, ROURKELA got the status of smart city. In the recent past, in January 2023, Men's Hockey World Cup was played here in the newly constructed Birsa Munda Hockey Stadium, which is one of the biggest stadium having maximum seating capacity in the world. We are really proud of ROURKELA. I would like to take this opportunity to thank all the members of the organizing committee who have worked tirelessly to make this conference a grand success. I would also like to thank all our sponsors, partners, speakers, moderators, panelists, volunteers, and staff who have contributed to this event in various ways. The ROURKELA Taxpayer Association was formed in the year 1989 with the vision of promoting education, research, and advocacy in the field of taxation. Our members include advocates, chartered accountants, tax consultants, and other professionals who deal with various aspects of direct and indirect taxes. Presently, we are having 97 members in our ROURKELA Taxpayer Association, which includes advocates, chartered accountants, etc. We aim to provide a platform for our members to exchange views, share knowledge, and update themselves on the latest development in tax laws and practices. We also strive to represent the interests of our members and the taxpayers before the authorities and the judiciary. Since its inception, the ROURKELA Taxpayer Association has been actively organizing seminars, workshops, webinars, conferences on various topics related to taxation. Ladies and gentlemen, this conference is a testimony of our dedication and enthusiasm for our profession. It is my privilege to share with you a remarkable story of a family that has dedicated their lives to the noble profession of law, a family that has not one, not two, but 3 generations of lawyers practicing together in the same bar association, a family that is an inspiration to all of us who aspires to uphold justice and serve the society. This family is none other than senior advocate Mr. Hariram Agarwal's family, who are members of the ROURKELA Taxpayer Association. Mr. Hariram Agarwal's family consists of Mr. Hariram Agarwal, the grandfather, Mr. Sanjay Agarwal, the son and the past president of ROURKELA Taxpayer Association, and Mr. Avas Agarwal and Ayush Agarwal, the grandsons. All 4 of them are eminent tax lawyers who have handled many complex and challenging cases in their respective fields. Give them a big round of applause. In the year 2006-07, we organized the first physical conferences on taxation at Amar Marriage Palace, ROURKELA, where 2 sitting judges from Supreme Court and Supreme Court of India and 3 High Court judges, including the Chief Justice of Odisha High Court, attended the function and graced the occasion. Again, in the year 2020-21, in the month of January 2021, we organized our second physical conference at NIT campus, ROURKELA, where a large number of delegates and speakers across the country attended, and it was a grand success. We have also been collaborating with other professionals, associations, and institutions to enhance our reach and impact. We are proud to host this National Tax Conference, which is one of the flagships event of AFTP. We have invited eminent speakers from across the country to enlighten us on various aspects of taxation. We hope that this conference will enrich your knowledge, update your skills, and inspire you to face the challenges ahead. I request you all to join me in welcoming them with a round of applause. Thank you for your attention. I wish you all a fruitful and enjoyable conference. Jai Hind.
Thank you so much, sir. It gives me immense pleasure to invite Conference Chairman, Advocate Subhash Chandra Agarwal, to present the welcome address.
His Lordship, Honorable Mr. Justice Subhashish Talpatra, Chief Justice, Odisha High Court, His Lordship, Honorable Mr. Justice Chittaranjan Das, Judge, High Court of Odisha, President, All India Federation of Tax Practitioners, Advocate Sri Pankaj Ghia, President of All India Federation of Tax Practitioners, East Zone, Advocate Sri Basudev Chatterjee, President, All Odisha Tax Advocates Association, Sri Uttam Behra, and our President, RTB President Sri R.K. Misra, esteemed speakers, honorable delegates, respected guests from GST and Income Tax Department, guests from our parent bar, ROURKELA Tax Bar Association, members from Institute of Chartered Accountants and Institute of Cost and Works Accountants, different personalities from ROURKELA Chamber of Commerce and Industry, persons representing different industries and other commercial establishments, friends from press and media present in this August House. I welcome all the students National Tax Conference Gyan Setu, organized by Steel City Smart City ROURKELA, situated on the bank of Triveni Sangam, the meeting point of three rivers, that is Sank, Koel and Brahmani at Bedvyas, just 2 kilometers from the venue, and it is believed to be the birthplace of Rishi Bedvyas, who manuscripted the great epic Mahabharata. ROURKELA is a steel city, and rather it would be appropriate to say it is a steel hub, having the most prestigious mega PSU ROURKELA steel plant, whose steel is used in defense and other critical infra projects. Besides, more than 100 other big and small steel factories are there at ROURKELA and its adjoining areas. It is a cosmopolitan city, sir, where people from all parts of India reside. The city hosted Hockey World Cup. The city hosted Hockey World Cup in January 2023, and for your information, it is a home to the biggest seated hockey stadium in the world. It has the biggest capacity. We are hosting this 2 days National Tax Conference under the banner of All India Federation of Tax Practitioners. Our two such events in the past, one in 2007 and other in 2020, have encouraged us to venture for this conference, and we are totally confident this time too it shall be grand success. Sir, the thrust of hosting of this conference is to aware the August gathering on the areas of GST and income tax. As we know, GST has completed 6 years of its introduction, and it was termed to be good, and it was termed to be simple and good tax in the beginning. But after the 6 years of its implementation, we as professionals does not find it this concept. It is the most critical law, where the lawyers and chartered accountants remain pondering as to what advice should be given to our clients. More than 100 amendments, numerous circulars and notifications are issued, which becomes bumpy road for the professionals to travel. Similarly, sir, there has been lot of changes in Income Tax Act as well, and in new regime of reassessment proceedings under Section 148 is one area where disputes and litigations are refusing to settle down. Therefore, keeping all these in view, we have invited best brains to this conference who will enlighten you on the subject and explain how to handle the various GST and income tax problems. We sincerely hope the delegates will enjoy the deliberations as well as the personal fellowship over this 2 days conference. We are really indebted to His Lordship, Honorable Chief Justice Sri Subhasis Talpatra, and His Lordship, Honorable Justice Sri C.R. Das, who have taken all pains to travel from Cuttack to ROURKELA to grace this occasion. I thank all the esteemed speakers who have traveled from distant places to share their knowledge with the delegates, without whom we could not have been able to have such overwhelming response. Finally, sir, I would like to thank all the members of RTBA and conference committee, particularly young members, who have been working tirelessly day and night to make this conference a grand success. Thank you, sir. Jai Hind, Jai Jagannath.
Thank you, sir. I now invite President, All India Federation of Tax Practitioners, Advocate Pankaj Ghia, to please present his address.
जय जगन्नाथ. एक बार और जय जगन्नाथ. Friends, what a amazing day, fantabulous day. The family, I would simply say, what an amazing gathering and what an amazing guest we have today. And we need a big, big clapping for the honorable guest, Honorable Mr. Justice Subhashis Salpatra and Honorable Mr. Justice Chittaranjan Das. Sir, we are privileged and proud that you had accepted our invitation and you are here. And this shows the jam-packed house which is here to welcome you, sir, on this day. You can understand, sir, when Mr. Mishra was talking about the ROURKELA Tax Bar Association, they have 97 members and we have stopped the registration at 300 20 days back. That was the attraction of my lords coming here to inaugurate this National Tax Conference hosted by the ROURKELA Tax Bar Association and All India Federation of Tax Practitioners. And friends, that is the power of the tax professionals, that we are always coming as a family together to listen to the honorable guests and listen to the honorable learned speakers which are coming from all over India. I would also like to congratulate you all, being this the 105th program of the AIFTP this year. It is in the series of programs we are organizing tax conferences, webinars, seminars, and every weekend we are having one program at one of the places throughout India. And I am traveling throughout India, and it is all good wishes of the family of AIFTP that we are getting a gathering of not more than 300-400 people in every conferences throughout India. Sir, we had tried a new thing this year. We had tried to mix religion with education, and the result has been phenomenal. And the trial had started from Odisha, because in February first week we had organized a national tax conference at Puri. And with the blessings of Lord Jagannatha, I had completed 105 programs this year, and it is only and only because of the blessings. And Mr. Vivekanand Mohanty was one of the key instrument person organized that conference. Thereafter, in the month of March, we went to Ayodhya. In the month of April, we went to Chitrakoot. In the month of May, we went to Mahakal and Omkareshwar. In the month of June, we went to Tirupati. In the month of July, we went to Amritsar Golden Temple. In the August, we are still going. I had already visited Rameshwaram. And then, very recently at Shirdi with 3 Jyotirlings, the Trambakeshwar, Bhimashankar and Krishneshwar. And then in September, we are going to Bake Bihariji, Mathura Vrindavan. October, we are working with Bodh Gaya and other programs. In November, we are going to Kashi Vishwanath. And at all these places, the national tax conferences has been held, and the gathering was not less than 400 people in any of the places. And what a wonderful, wonderful year of the tax professionals it has been. Sir, we are also have a wonderful this year for another reason. 2 of our members had been elevated to the Honorable Supreme Court this year, and we are proud of it. Honorable Mr. Justice Rajesh Bindal was elevated in the month of February, and we had a felicitation function at Delhi, and then he had been coming as a chief guest in various functions. And then recently, Honorable Mr. Justice Ujjwal Bhuya had been elevated as the judge of the Supreme Court of India, and we had a felicitation function at Delhi in 10 days back at Delhi. And this is a proud moment for AIFTP, though both had been the members of AIFTP, and amongst other many judges of the High Court which has been elevated from the tax fraternity and the members of AIFTP. This was the 3rd elevation of the AIFTP member as the judge of the Supreme Court, the first being Honorable Mr. Justice Arijit Pasaya sir. So 3 judges from the AIFTP adorning the bench of the Supreme Court. It is a feather in the cap, I would always say, and we are greatly proud of it. Sir, we look forward as all the tax professionals be it a chartered accountant, advocate, or a tax practitioner, as a family. And this year, we thought, let's celebrate the 77th Independence Day as a family together. And on the call of the national body, AIFTP, we celebrated Independence Day at 151 locations throughout India at one day on 15th August. And that is a record in itself for all of us. And a big clapping for all of us for that. AIFTP is 11,000 plus tax professionals body representing all tax professionals pan-India. And it is the only one body apart from the statutory bodies like Bar Council or the Institute of Chartered Accountants that is representing the interest of tax professionals. We are coming out with tax publications at a concessional rate for the benefit of members. We are coming out with the regular journals on direct tax and indirect tax every month, and it is being circulated to our members. We are coming out with the information through the website and mail of the latest tax laws, latest amendments, latest notifications, and latest judgments of the all high courts and the Honorable Supreme Court. And then we are contributing through our members by giving our experience and our inputs as information and education to the young members. We had seen that young members are eagerly joining the federation this year, and we had a great opportunity coming out. Sir, we have also one thing. The old adage that charity begins at home, we try to follow it with AIFTP members, and all the office bearers, the speakers who are the members of AIFTP don't charge anything for coming, for delivering, including their transportation and stay, and pay their registration of the conference also. And this is what AIFTP is. This is what we look forward. We are not friends. We are not professionals. We are one single family representing India tax professionals throughout India. And be a family member of AIFTP. That is what I say. Sir, we are proud and privileged you had come here. It is a great moment for ROURKELA. I still remember at Puri when we discussed about organizing this conference with the officers, office bearers of the ROURKELA tax bar. And there were some things whether it would happen or not. But with your blessings and with your patronage and with your coming, sir, it has happened. And it happened in such a magnificent way, a great way. 300 delegates and lot of delegates which we have refused registration. And this is what we look forward to it. Thank you, sir, from a core of our heart for coming. Thank you on behalf of all the delegates. And I thank you all the friends, the family members who had participated this evening, this two-day conference, in coming and encouraging and spreading the word of education in the tax profession. Sir, lastly, I would simply say, AIFTP stands for 3 E's: ethics, education, and excellence. We believe following the ethics and the education, excellence comes automatically. You always become an excellent person if you follow the ethics and education, if you take the education and follow the ethics. And sir, AIFTP stands for it. I am grateful to all the members of the ROURKELA Tax Bar Association, Mishra ji, Subhash ji, Dilip ji, and all. I would not be naming some person or not the other person, and the office bearers of my AIFTP East Zone with Vivek Agarwal, Basudev Chatterjee and all, who had taken all pains to make this conference memorable. We will be organizing the National Convention at Kolkata this year on 22nd December, and I request you to join it in large number apart from all other programs of the AIFTP. And lastly, friends, visit the website of AIFTP. It is a dynamic website. You will get the information, education, and everything about the AIFTP activities. And come and join AIFTP in large numbers. Thank you, sir. Thank you for coming here.
Thank you so much, sir, for that inspiring and enthusiastic speech and spreading positive energy. among all present here. Thank you so much. I feel honored to invite AIFTP East Zone Chairman, Advocate Basudev Chatterjee sir, to please deliver his address.
Thank you, madam. You have given me some time to speak something before this hall and before the delegates and the participant present here. Thank you. Sir, Majesties, Lordship, Sri Subhasis Talapatra ji, Honorable Justice Sri Chittaranjan Das Sahab, we are very much proud to have you in this organization as our guest and guest of honor. मुझे गर्व है कि आज हम सभी आप ही के साथ है और आपका आशीर्वाद से हमने ये ऑर्गेनाइजेशन को बहुत बढ़िया अरेंजमेंट किए हैं और मेरे नेशनल प्रेसिडेंट साहब श्री पंकज गिया जी पूरा ही बात सब कुछ तो बोल दिए आप लोगों को, मुझे ज़्यादा और कुछ नहीं बोलने का है। और एक बात हम बोले कि आप ज़रूर मेरा जो AITP का जर्नल है, जर्नल जो आप लोग जर्नल को सब्सक्राइब कीजिए, उसको पढ़िए, बहुत इंटरेस्टेड है, बहुत सारी चीज़ उसमें है जो आप सीख सकते, जान सकते। तो ये सभी ने हमारे गिया साहब जी के सफल और बहुत परिश्रम के बाद इन्होंने ये सफल बनाया। बहुत बहुत धन्यवाद सबको, बहुत बहुत धन्यवाद सर।
Thank you so much, sir. I feel extremely privileged to invite to the lectern our guest of honor, Honorable Justice His Lordship Sri Chittaranjan Das, Orissa High Court. Before that, a brief introduction of our guest of honor. Honorable Justice Sri Chittaranjan Das was born at ROURKELA on 12th November 1964. His Lordship began his schooling in ROURKELA BS High School, Sundargarh, and Ispat Vidyapit, Sector 18, ROURKELA. He enrolled as a lawyer in the Orissa State Bar Council in the year 1988. He was also a member of Arbitration Society and conducted arbitration by visiting different places in the state of Orissa and Jharkhand. He got posted as ad hoc additional district and sessions judge Cuttack in the year 2004. His lordship got transferred to Kandhamal to deal with riot cases and conducted the prominent trial in a murder case of Hindu saint Swami Lakshmananda Saraswati. Shri Das was posted as 3rd and 2nd Additional District and Sessions Judge Cuttack, Special Judge Vigilance at Kalahandi, served as Registrar Judicial in the Honorable Court and District and Sessions Judge Raigada, and as Registrar General Orissa High Court since March 2021. His Lordship took oath as a judge in Honorable Orissa High Court on 13th August 2022. We are pleased to invite to the lectern our guest of honor, Honorable Justice His Lordship Sri Chittaranjan Das, sir.
Jai Jagannath, a very good morning, Namaskar. My Lord the Chief Justice, Orissa High Court, the Chief Guest of the inaugural session of the conference, Gyan Setu, the Chairman Conference Committee, dignitaries, Mr. Basudev Chatterjee, Mr. A.K. Mishra, Mr. Gia, Mr. Subhas Agarwal on the dais, the dignitaries of the dais, my friends of the legal fraternity, all the guests, invitees, members of print and electronic media, ladies and gentlemen. I feel very nostalgic having come to ROURKELA after a long period. During my last visit, when there was a felicitation program by my own bar, my senior Mr. Agarwal, Mr. Dilip, they all had been to the bar and invited me and also made a request that you should have Chief Justice for inauguration of this August conference. Thereafter, Mr. Sanjay happened to be my friend during my practice career. He sent a program where I found my speech was for half an hour. Then I couldn't say him anything. I took it reserved to have a consultation with him and to reduce it. But then I prepared a speech. Let me see how long it will go. And the speech I prepared contained 25 pages. So I thought, no, this is not in fact viable. Let me talk to Mr. Agarwal and reduce it to 10 minutes. Then again I prepared a speech and I found it is of 10 pages. As you know, in a ceremony when the welcome is addressed, normally it is the guests who are being welcomed. But here I found Mr. Mishra gave a vivid speech also. And most of the speech that I had prepared in the 10 pages has been covered. So whatever remained, again I changed my mind here that all right, if Mr. Mishra has told about my speech, I will turn it to the spiritual side. Again Mr. Ghia has taken that. So virtually I deleted all and I have nothing to speak about you. I will simply repeat in a different tone. It is indeed a proud privilege for me to be here amidst this august gathering. Being the son of this soil, I am certainly not a guest to this momentous occasion. The sole reason of lending my consent to be the guest of honor is to witness the gracious presence of the Chief Justice in this intellectual event and remain as a bridge between the organizers and my Lord the Chief Justice. This being a national conference is a host to a constellation of legal luminaries from different parts of the country, and it's always a matter of great joy for me to get people to see and explore this remarkable city of ROURKELA, not just because it is my birthplace, but also because it has a lot more to offer from one can think of. Welcoming people from around the globe is not unknown to this magnanimous city, as it had grandly opened its arms to people all over the world when it hosted the one-of-a-kind, the World Cup. And I congratulate the ROURKELA Tax Bar Association for organizing the conference in the city, which is known for so much more than the steel city, ROURKELA, or the smart city. As you all know, the conference provides an unmatchable platform to put all our heads together and exchange our views on the critical topics that would be discussed through and through the different sessions to commence afterwards. An insightful deliberation to assess the pros and cons of the fiscal policy, taxes, GST by the esteemed delegates participating in the conference would most definitely help the government in further making economic decisions of paramount importance for the betterment of the vast population of the country at large. As Mr. Mishra has said, the ROURKELA Tax Bar Association has been conducting the symposium, workshop, training and seminar. Not only helps in enhancing the knowledge and developing acumen on a given topic, but also helps in boosting the confidence of the new entrants to the profession, for whom initiatives like such is a medium to gain initiative, perspectives and develop familiarity with the different facets of the profession. It would be my humble request to the ROURKELA Tax Bar Association to conduct more and more such enlightening initiatives that are educative, creative and could address the economic concerns of the public at large in times to come. I'd like to take this opportunity to reiterate that I in fact fulfill my commitment that I made to Mr. Agarwalji and Dilipji during my last visit to ROURKELA, where they requested me to get the national conference inaugurated by the Chief Justice of the Odisha High Court. The moment the opportunity presented itself, I grabbed it, and here we are in the conference under the able leadership of my Lord the Chief Justice, Justice Talpatra. Of course, that being said, I cannot take the entire credit for making it possible, because ever since my last visit to ROURKELA, Brother Sanjay has not left any stone unturned in reminding me of the promise I made to him, which all more kept me on my toes in ensuring that I stand by my words. I'd like also to take this opportunity to mention that Chief Justice, my Lord Justice Talpatra, is a judge of repute and is also known to have diverse experience as a professional. I consider myself to be very lucky to have the opportunity of listening and learning from him on many occasions. His versatility in subjects of law and topics other than that is very well reflected in his speech, not just within the country, but his lordship has been entrusted to represent the country on various platforms and occasions abroad as well. This is one thing I can assert with certainty, is that the audience is always left amazed by the erudite speech of his lordship. Without much ado, I would request all of you to welcome my Chief Justice with a big round of applause to show him gratitude for the magnanimity he exhibited in accepting the humble invitation and for traveling all the way from Cuttack after the court hours yesterday and for giving us a precious time out of his busy schedule. Personally, I am indebted to you, sir, for having kept my request. I would once again congratulate all the members, delegates of this August conference, and having taken a decision to have this conference in ROURKELA, I am greatly inspired with this effort taken by the Tax Bar Association, and my special gratitude to all of you for having given me an opportunity to speak a few words before this gathering. Thank you. Thank you.
Thank you so much, sir. Thank you for adding a spark of humor on this somber occasion. We are indeed happy to have you. I am extremely overwhelmed to get this opportunity to humbly introduce our chief guest, Honorable Chief Justice, His Lordship, Shri Subhashish Talapatra, Odisha High Court. May I present a brief introduction of His Lordship. Honorable Chief Justice Shri Subhashish Talapatra was born on October 4, 1961 at Udaipur, Tripura. He did his graduation in Arts and Law from University of Kolkata. He was enrolled by the Bar Council of Assam, Nagaland, Meghalaya, Manipur, Tripura, Mizoram and Arunachal Pradesh on September 12, 1990. He was sworn in as an additional judge of Guwahati High Court on November 15, 2011. His Lordship took an oath as permanent judge of High Court of Tripura in the year 2013. His Lordship officiated as the acting Chief Justice of the High Court of Tripura with effect 12 November 2018 to 13 November 2018 and with effect 11 November 2019 to 15 November 2019. He held the positions of Executive Chairman, Tripura State Legal Services Authority, Chairman Juvenile Justice Committee, Chairman Computer Committee and E-Courts Project, Chairman Committee for Establishment of National Law University, etc., and member of Krishna Water Disputes Tribunal since 2018. His Lordship was transferred as Judge, High Court of Orissa, and took oath of office in the High Court of Orissa on 10th June 2022. His Lordship took oath as Chief Justice of High Court of Orissa on 8 August 2023. I invite His Lordship to the lectern. Thank you so much.
So I extend my warm greetings to all who have assembled today, which you have acronymed as Gyan Setu. It should be an illuminating intellectual exercise to understand the spectrum of taxation practices in our country. My esteemed colleague, Justice Chittaranjan Das, I was a little bit confused a few minutes back whether he has crossed the floor or joined the Tax Bar Association of ROURKELA or not. Anyway, I thought he is masquerading because of the strong emotion he holds for this place and the Bar Association. Mr. Pankaj Khia, the National Chairman of the AIFT, Mr. R.K. Mishra, President RTBA, Mr. Basudev Chatterjee, East Zone Chairman AIFT, and Mr. dear Subhash Chandra Agarwal, the Conference Chairman. And of course, those who are off the dais and known for your eminence as a tax practitioner in different places of this country. Ladies and gentlemen, I was really humbled by your affection that you have shown towards me and your blessings that you have showered on me. I really find it to adjust because I do not know whether I hold that height or not. But one thing in common in you and myself is that we started our career as a lawyer. I have raced to the other side of the river. Sometimes it looks like really river, there is no bridge between the bar and the bench, and this should not happen. I think only bridge that now you are constructing is the Gyan Setu. There is a common thread between us. We are every moment to learn, unlearn, and relearn in the legal world, and there is no full circle to that. Every time it is so dynamic, every time it was so changing. And Mr. Mishra was saying it's very difficult to catch hold of the exact shape of a particular tax law. Every day, every moment, these are changing and getting interpreted by the tax executives. We live in this world of uncertainty with a lion's heart that we must give justice to the person who really need it, who are not caused by unreasonable tax, arbitrary and illegal imposition of tax, both direct and indirect. And this is a huge task, because we know the charting to this profession is so many hurdles. It's all good in having a conference in this air-conditioned conference hall, and the moment you go outside, you know your client is sitting on your head, and you are so helpless to get the relief from the court. That's really, really very difficult. And I had experiences of sitting days after days to get the matter decided by a court, and the person outside the court, judge doesn't know his face also, doesn't know what is the problem this gentleman is approaching that court. Only the lawyer does know it. And lawyer becomes such a helpless creature in between the judge and the litigant. Despite his best efforts, he cannot get the matter decided through the process of the court. Don't think that we do not understand who are sitting as a judge in different courts. At the same time, our helplessness is more grave and more serious, because when you start a hearing a case, that lawyers want to submit more, and they think this is more material I must place before the court so that the court can appreciate my submission, my points, and my reasons. And court, behind the back of a judge, a clock is always ticking. You close it early, other matters is waiting on the board. And this is a really very tough situation a judge to handle every day, sitting on the dais. Sometimes we are misunderstood. Sometimes we are told this judge is very arbitrary, doesn't permit us to place our argument. This is happening. Only a few days back, an eminent jurist stated the number of cases pending in different courts of India. To get this resolved will take 350 years only. And a man's lifespan maybe 75 to 80 years. Only a few days back, I was hearing a civil second appeal. The appeal was filed in the Orissa High Court in 1957. And suit was instituted on the pre-independence day of 1937. Think of that litigant. We always keep that litigant in our mind. And I confess to you that our judicial infrastructure is so inadequate. The number of courts that we require, the infrastructure support system that we require, we do not have that. You will see in the different high courts, there are about 1,092 judges posted there. And perennially over the last 10 years, the 40% vacancy could not be ever filled up. So these high courts are running with the 60% strength. And in per capita case in the US, is only per judge per capita case per annum is only 72. And in our country, it is around 25,000. So you want justice, you want the scope of the fair hearing. I think it is next to impossible. But we are trying with the possibles. And we are trying to devote our time for this purpose. So in such scenario, you must discuss about the system, how the system can be reformed, how the system can be simplified, how the system can be predictable. As Mr. Mishra was referring to, that there is no end to the income tax litigation because of Section 148. That always there is a reopening of the assessment. The person again taken to the very first point, from which point he has started from the assessment. And in most of the cases, my experience says, out of 100 cases, 80% cases doesn't have any foundation at all. So who will make those tax executive responsible? This is a big question that should travel through our minds. There is no filtering mechanism. Why? Nobody is ready to take the responsibility. Everybody has a fear that against me, there may be a vigilance complaint. And for these, they are putting the ordinary SSCs, those who are running a small business, medium-sized business, doing the professional practices. They're scared of our system. And they are the big contributors of our revenue. So there should be some assessment, some level, and the level must be in the level who can legislate, not the judges, not the tax practitioners. They must have a very strong committees. Even before the GST was introduced, we all know there was a strong committee was set up. And what was the ultimately happened? The most of the recommendations of the committee were discarded by the executive who drafted the rules and created a lot of problems. Because the legal experts suggested things, from their experience they thought that will work properly, harmoniously, and without any difficulty. And those clauses were just discarded. I remember this Arvind Datta was making a speech in the Bombay High Court Tax Bar Association. He was saying that I have worked in Nani Palkiwala. I have learned a little bit of the income tax law. I have learned a little bit of the indirect taxes. This legislation was unthinkable as a student of law. But who are we to criticize? As a judge, we have to just administer the justice according to the law which has been produced before us. But as a citizen of the country, we have definitely certain concerns. Only a few days back, I was just reading in a very important paper. The paper's name is a Tax Policy for Developing Countries. Don't get worried, I will not take much time. Why do you have taxes? The simple answer is that until someone comes up with a better idea, taxation is the only practical means of raising revenue to finance government spending on the goods and services that most of us demand. Setting up an efficient and fair tax system is, however, far from simple, particularly for developing countries. To that category our country belongs, that want to become integrated in the international economy. The ideal tax system in this country should raise essential revenue without excessive government borrowing and should do without discouraging economic activity and without deviating too much from the tax system in other countries. What exactly our journey is just going away from the globalized tax system and so-called indigenous tax system having its own problems, maladies, and difficulties. The developing countries face formidable challenges when they attempt to establish efficient tax system. First and foremost, workers in these countries are typically employed in agriculture, in small and informal enterprises, as they are seldom paid a regular fixed wage, their earnings fluctuate, and many are paid in cash off the books. The base for income tax is therefore hard to calculate, nor do workers in those countries typically spend their earnings in large stores that keep accurate records of sales and inventories. As a result, modern means of raising revenue, such as income taxes and consumer taxes, play a diminished role in these economies. And then there is an interesting comment. In the developing countries, tax policy is often art of possibles rather than pursuit of the optimal. In our country, tax is treated as almost an instrument to optimize the entire state's revenue without giving the quid pro quo for payment of the tax. The developed country, they are not only extract the tax, they give you the social service securities in certain level. After the age of 60, like in the countries like Canada, they provide the social security services in consideration that you have paid tax, and that encourages the payment of tax, income tax, and other sort of indirect taxes. There is an interesting comment has been made. In developing countries where market forces are increasingly important in allocating resources, the design of the tax system should be as neutral as possible, as to minimize interference in the allocation process. The system should also have simple and transparent administrative procedures so that it is clear if the system is not being enforced as designed. So therefore, we pay tax, and on the next year, the necessity of imposing increased tax comes from the mismanagement of the revenue that would be generated earlier year. And Parliament cannot make this the wrong, frustrating allocations to come to a halt, so that the persons who are paying tax can have a sigh of relief that at least this year my assessment will be like that of the earlier year. What happened in our country? There is a typical scenario that has emerged, that our corporate doesn't pay the maximum share of the revenue. It is paid by the other segment. Therefore, a lot of manipulation takes place in the highest level, and that when that is discovered, the manipulation of the banks, financial institutions, throwing the money to the informal sectors, these are the common known, the ill side of our taxing system. Our taxing system is that. In this advanced country, the tax system is a little bit predictable. It doesn't happen every now and then on fall of hat, system is reformed. But developing countries like ours, interest income, if taxed at all, according to me, it should be taxed as a final withholding tax, as a rate substantially below both the top marginal personal and corporate income tax rate. The tax treatment of the dividends raises the well-known doubt of double taxation issue. For administrative simplicity, most developing countries would be well advised either to exempt dividends from the personal income tax altogether or tax them at a relatively low rate, perhaps though a final withholding tax at the same rate as that imposed on the interest income. These are two such, I'm just touching these points. Finally, there is an issue regarding the depreciation of the assets. There is completely unbridled, assessment is unverified, and also when the assessment is taken in the name of so-called assessment, this happens sometimes, this becomes instrumental to push a person to such a piquant situation. As a practitioner of the tax, you cannot find any ways what to do with that. That is not guided by any sort of protocol, as yet, almost after tax law's journey of more than now 50 years. Therefore, the suggestion that IMF has made, I've just for your information, they made 4 small suggestions. Classifying assets into 3 or 4 categories should be more than sufficient. For example, grouping assets that is last a long time, such as building at one end, and first depreciating asset such as computers, and other with 1 or 2 categories of machinery and equipments in between. 2, only 1 depreciation rate should be assigned to each category. 3, depreciation rate should be generally be set higher than the actual physical lives of the underlying asset to compensate for lack of a comprehensive inflation compensation mechanism compensation mechanism in most tax systems. On administrative, third and last one is, on administrative grounds, the declining balance method should be preferred to the straight line method. The declining balance method allows the pooling of all assets in the same asset category and automatically accounts for capital gains and losses from the assets disposals, thus substantially simplifying the bookkeeping requirements. So these are the issues. Because you are the very eminent tax professionals, we always think you are practicing every day on the extant laws, but as a body of the tax professionals, you must be very active and alert how our tax system should be reformed for our future generation. Before I just conclude my speech, I thank you very much for this warm hospitality. I enjoyed every bit of moment being here. And also I congratulate Abbas and Ayush Agarwals. These are young tax professionals. Those are coming up with robust strength, with a very clear vision about their practice. I welcome you and wish you all the best. Thank you very much.
Thank you, Your Lordship. Your presence this morning shall indeed inspire and motivate all present to pursue and keep going in this profession with ever-changing dynamics. Moving on, I would like to request all dignitaries on dais to launch the souvenir, and I request Advocate Dilip Kumar Singh, Souvenir Chairman, to please present the souvenir to our Chief Guest, His Lordship Chief Justice, Orissa High Court, Shri Subhashish Talapatra, for release. Ladies and gentlemen, leading experts have contributed in this edition, which is now being released by our Chief Guest, His Lordship Chief Justice, Orissa High Court, Shri Subhashish Talapatra. Thank you so much, sir. Dear audience, we will now acknowledge our esteemed guests on dais, especially our Chief Guest, Honorable Chief Justice, Orissa High Court, and our Guest of Honor, Honorable Justice, Orissa High Court, to have taken their valuable time off in order to be with us today by felicitating them. I request Advocate Shri Radhe Shyam Agarwal to felicitate His Lordship, Honorable Chief Justice, Shri Subhashish Talapatra, Orissa High Court. May I please invite Advocate Shri Radhe Shyam Agarwal ji. Our Chief Guest is being felicitated with a shawl and also a memento. Ladies and gentlemen, please give a big hand for the felicitation of our Chief Guest, His Lordship Shri Subhashish Talapatra. We present a memento. Thank you, sir. I call upon Advocate Hari Ramji Agarwal to please felicitate His Lordship, Honorable Justice Shri Chittaranjan Das, Orissa High Court. Advocate Hari Ramji Agarwal. His Lordship, Honorable Justice, will be felicitated with a shawl first, followed by a memento. Thank you so much, sir. Next, I call upon Advocate Karthik Kurmi to felicitate AIFTP President Advocate Pankaj Ghia. I request, Sir, Mukul Gupta ji to please come up to felicitate. Take care. He is also being felicitated with a shawl and a souvenir. I call upon Advocate Lalan Prasad Singh to felicitate AIFTP East Zonal Chairman Advocate Basudev Chatterjee. Advocate Lalan Prasad ji. He will be felicitating AIFTP East Zonal Chairman Advocate Basudev Chatterjee ji. This very solemn moment of a senior practitioner. Ladies and gentlemen, please give a hand to Advocate Lalan Prasad Singh. He will now be felicitating Advocate Basudev Chatterjee with a shawl. And a memento. Thank you so much, sir. May I please request Advocate Subhash Chandra Nayak to felicitate ROURKELA Tax Bar Association President Advocate Ramakrishna Mishra. Subhash Chandra Nayak ji. Please felicitate RTBA President Advocate Ramakrishna Mishra. First with a shawl, followed by Thank you, sir. I call upon Advocate Gokul Chandra Patri to felicitate Conference Chairman Advocate Subhash Chandra Agarwal. Advocate Gokul Chandra Patri, if you are here in the hall, please come up fast. We are having the felicitation ceremony, and I invite you, Advocate Gokul Chandra Patri, to please felicitate Conference Chairman Advocate Subhash Chandra Agarwal. Advocate Subhash Chandra Agarwal will now be felicitated with a shawl, followed by a memento. Thank you so much, sir. With that, I will now invite to the lectern CA Rajesh Patnaik, past Chairman, ROURKELA branch of ICAI, to propose the vote of thanks.
Honorable Shri Justice Subhashis Talapatra Sir, Chief Justice, High Court of Odisha, Honorable Shri Justice Chitranjan Das Sir, Justice, High Court of Odisha, Advocate Pankaj Ghia Sir, President, All India Federation of Tax Practitioners, Advocate Basudev Chatterjee Sir, East Zone Chairman, AIFTP, Advocate R.K. Mishra, President RTBA, Advocate Subhash Chandra Agarwal Sir, Conference Chairman, invited dignitaries, members of the press, my dear colleagues, ladies and gentlemen. It is my privilege to have been asked to propose a vote of thanks on this memorable occasion. American motivational writer William Arthur Ward rightly said, "Feeling gratitude and not expressing it is like wrapping a present and not giving it. Therefore, first and foremost, we from ROURKELA Tax Bar Association, from the core of our heart, profusely thank Honorable Shri Justice Subhashish Talapatra Sir, Chief Justice Odisha High Court, who despite his busy schedule has found time to grace this occasion and share his inspirational thought. Sir, after hearing you today as tax professionals, we are so confident that we are all in the right direction. You have touched upon those issues which we are facing day in, day out. Thank you, sir, for giving us this confidence. We must mention our deep sense of gratitude to Honorable Sri Justice Chittaranjan Das, Justice Odisha High Court, for his continuous encouragement and support to the legal fraternity in ROURKELA. Our heartfelt thanks to Advocate Pankaj Ghia Sir, President AIFTP, for his august presence on this occasion. It means a lot to us at RTBS, sir. We acknowledge our gratitude to Advocate Basudev Chatterjee, sir, East Zone Chairman, AIFTP, for his encouragement for this event. Our sincere thanks to all the delegates who have come from across this country, without whom this conference would not have been possible. We are a very small association. Thank you all for making it to ROURKELA. A big thank you to the members of the press for giving this event wide coverage. We thank the speakers who have traveled from across the country to be in a small place like ROURKELA with no airport facility. Thank you all. I'll be failing in my duty if I don't thank our RTBA President and our conference chairman who have taken all the pain to assemble such stalwarts and dignitaries to ROURKELA, which lacks an airport where direct flights are not possible. Last but not the least, I thank the management of Pahadi Hotel for their enormous cooperation. Before I conclude, a small thought. Learn everything you can, anything you can, from anyone you can. There will always come a time when you will be grateful you did. Happy learning. Jai Hind.
Ladies and gentlemen, a special mention and a special felicitation for Advocate Karthik Kurmi for reaching the Supreme Court. He is the first member of Bar to practice in the Supreme Court. I request Advocate Karthik Kurmi to please come forward for his felicitation. He's not there? Additional Commissioner of State Tax, Shri Anand Kumar Malik. I welcome Additional Commissioner of State Tax, Shri Anand Kumar Malik. Thank you so much for coming, sir. Thank you. Additional Commissioner of State Tax, Shri Narendra Kumar Meher. May I please welcome Additional Commissioner of State Tax, Shri Narendra Kumar Meher. Joint Commissioner of State Tax, Shri Jugal Jagdala. we welcome Joint Commissioner of State Tax, Sri Jugal Jagdala. Please give a big hand. Ladies and gentlemen, Joint Commissioner of State Tax, Sri Abhay Vincent Mins. Joint Commissioner of State Tax, Sri Abhay Vincent Mins. Joint Commissioner of State Tax, Sri Basant Kumar Korkora. Sri Basant Kumar. Deputy Commissioner of State Tax, Sri Sushant Kumar Sahu. We welcome Deputy Commissioner of State Tax, Sri Sushant Kumar Sahu, with a bouquet. Deputy Commissioner of State Tax, Sri Jagadish Sa. Deputy Commissioner of State Tax, Sri Jagadish Sa. Additional Commissioner of CT and GST, Sri Abhay Gupta. Sri Ramesh Chandra Mandal. Sri Ramesh Chandra Mandal. Additional Commissioner of CT and GST, Sri Pramod Kumar Maurya, Marua. Sri Pramod Kumar Marua. Deputy Commissioner of CT and GST, Sri Harsh Raj. Sri Harsh Raj. Deputy Commissioner of CT and GST, Ashik Zaman. Deputy Director of CT and GST, Sri Ashish Kumar Sahu. President, ROURKELA Bar Association, Sri Pradeep. That's all? Okay. All right, thank you so much. Okay, Mr. Kurmi has not reached. All right. Thank you so much. With that, we come to the end of this inaugural session. And once again, we heartily express our gratitude, sir. His Lordship, Chief Justice, and His Lordship, Guest of Honor, to have come here and spend their valuable time with us. It was indeed an inspiration. Thank you so much. We'll take a break for lunch, and delegates can collect the conference souvenir from the registration counter on giving the souvenir coupon. Here's an announcement for the delegates. Delegates may collect the conference souvenir from the registration counter on giving the souvenir coupon. Our first technical session on GST will begin at 1:55 p.m. For the information of all delegates, our first technical session on GST will begin at 1:55 p.m. Thank you so much. Manoj Agarwal to please present a bouquet to Advocate Pankaj Khia. Thank you so much, sir. Next, I invite Advocate Bhavani Prasad Das to present a bouquet to CA Jatin Christopher. Bhavani Prasad Das, welcoming CA Jatin Christopher. Thank you so much. And now for a special felicitation for Advocate Karthik Kurmi. May I please have Advocate Karthik Kurmi on the dais? For reaching the Supreme Court. He is the first member of Bar to practice in the Supreme Court. I request our National President to please do the honors to felicitate Advocate Karthik Kurmi. We will now be felicitating Shri Advocate Pankaj Khia will be felicitating Advocate Karthik Kurmi with a flower bouquet, with a shawl and a memento. Our session speaker, CA Jatin Christopher, will be felicitating Advocate Karthik Kurmi with a shawl. And Advocate Pankaj Khia will be presenting a memento. We congratulate you for this special recognition, sir. Thank you so much. Thank you. May I please invite Shri Karthik Kurmi to present a small speech on this occasion.
Today, my friends have given a surprise to me since morning. What I have to say, where I have to do, what I have to do, I don't know anything. It's total surprise. I pray everybody, I request everybody, and thank you everybody for being in the ROURKELA. And the honorable guest and the dais. Now, after the coming of GST, at least, I think this is the second National Tax Conference in ROURKELA, and all the guests, they have come from all over India, and I welcome all of them. And they have shown so much of interest in the matters of GST, and they wanted to hear the esteemed speakers. For that, I thank everybody. Thank you.
Thank you once again, sir. Ladies and gentlemen, please put your hands together to welcome Advocate Pankaj Khia, National President, All India Federation of Tax Practitioners, to present his address. Sir, please.
Friends, the session after the lunch is always interesting. Interesting in the two sense, it tests the speaker and it tests the audience also. And the topic is really nice, the search survey and the precautions and what are the implications. In fact, even I was surprised in the morning when I was told that I would be the session chairman for this session. Sometimes we think why search is necessary. Once search is there are certain things what to do, what not to do, what precautions to be taken, what not to be taken. But have you ever imagined why the search would come to you? Have you ever imagined how to advise your client how to do some work so that the search may not come to you. There is no 100% guarantee that the search will not come. Normally what we foresee is that the search is because it is not the old times that there were some information, some complaints from the neighbor, some complaints from your accountant, some complaints from your competitor, that the search will come. Nowadays, more and more searches are because of the artificial intelligence, the computerized information, or the, some mistakes which are there in the reporting, and the mistakes are caught by the computer and it is then analyzed by the department. We have to see that aspect also. We have to see, are we purchasing fake bills? We have to see, are we getting goods from a fake supplier? We have to see, are we getting goods from a good supplier, but his supplier is a fake supplier? We have to see that there is some classification dispute or not. We have to see what we are purchasing and selling. The HSN codes are correct and the tax rate is correctly charged or not, or there is some AAR or AAR. RPG is here, other dear friends are here. They will know one AAR can make a survey happen to you because of a different classification. Apart from these major issues, the survey nowadays is not forthcoming for the simple reason that they don't want to catch a small fish. They don't want to catch a small fry in the ocean. The other issues are the mismatch, the misreporting or in the 3B or GSTR1 and the non-payment of taxes and so forth. But once a survey is there, once a search is there, what to do? Some bullet issues, Jatinji will take care of it. He is an expert, a fantastic speaker, a par excellent expert on GST, particularly on this topic. But some questions come whether there is a requirement of a presence of an authorized representative, be it a chartered accountant or an advocate or a practitioner. Should he go or should not go? What about the statement taken during the search? What could be if the search is there that it could not percolate in creation of demand? What could be done if search is there? Should we take an immediate legal action? Should we take a legal action after some time? Should we file a writ petition challenging the search itself? Should we file a petition challenging the summon itself? Should we file it after the show cause is issued? Or should we file it after the assessment order is issued, adjudication order is issued? We also know if it is related to the input tax credit mismatch and the fake bill and other issues, what to do in that circumstances? And what would be the impact of 16.2C and 16.4 and so on, and the non-payment of tax credits? We are also to see whether there was a transit penalty in our case, where some mistakes were caught, or the movement was caught with goods, without toll receipt, with toll receipts. Sometimes some are intelligent, blank truck only for the purpose of movement was coming and it was caught. It would necessarily result in a survey to you. So these are the things. If you don't challenge it at the first stage, could you challenge it at the stage of show cause notice or not? And what would be the impact? Because what would be the impact of the courts when we go to the courts? Normally some courts say, yes, we can entertain it at this level. Some courts say, no, show cause notice, you have an alternative remedy, will not entertain it at that level. These are some bullet points, some things. The proceedings, once an order is passed, the fate is sealed. We have to go through the statutory remedy unless and until there is a massive non-following of legal provisions. Otherwise, the court will not interfere. So everything, what has to be done is between the survey date and before or at the time of passing of the SCN or the issue of the SCN. Those are the crucial periods. Those are the periods where a consultant like Jatanji is required to advise you, to put you to give you a perspective what to do. And sometimes the client knows, we knows that what is being done is correct. The client has made a genuine mistake. Maybe in classification, maybe in bills, maybe in other issues. So we have to think about it, what to take, whether we have to take action so that we can cut off the penalties or not. These are many, many issues. The topic is so wide, I don't know how my learned friend would be able to cover it in the short sphere of time which is given to him. I will not be between you and him. I will simply say that the topic is apt and you have the best of the best person, a tax legend in his own might. A person whose YouTube video can be seen to understand the deep knowledge he has in the GST. Let's welcome Jatinji for this.
Thank you, sir, for giving us an insight into the subject. To welcome our session speaker, may I introduce our speaker to the audience. Jatin Christopher is a chartered accountant, cost accountant, and law graduate. He qualified in 1996 and specializes in indirect tax laws. He is a published author and a resource person for the Institute of Chartered Accountants of India in its various post-qualification programs on indirect taxation and extends support to ICAI in publication of educational and research material on various indirect tax topics. He is also a resource person for the government in conducting training for practitioners, trade, and officers. He has been in practice since 2000 as a partner in JCSS, a full-service firm with presence across India. Ladies and gentlemen, please put your hands together for the session speaker, CA Jatin Christopher.
Good afternoon, friends. It's my first time in ROURKELA, and it's a privilege to address on such an important topic where the participants are speakers themselves. All the participants I see here are experts in this field, and I consider it an opportunity for me to learn by exposing my mistakes that I have committed, so that you don't have to commit those mistakes. You should commit new mistakes. And my reason for coming all the way here is to learn from you and take back something new that is always there in GST. 90% of all search proceedings are illegal. 100% of all illegal proceedings are entertained by taxpayers. And the persons responsible are all in this room. It is we who don't stop taxpayers from surrendering to illegal proceedings. It's a very old decision of the Privy Council in 1936 ARPC 253, where the Privy Council said, when power is given to do a particular thing, that thing must be done in that particular manner or not at all. Karna ho to isi tarah karo, varna karo hi mat. Please bear in mind, the moment a question is raised, taxpayer becomes defensive. शायद हमने कुछ गलत किया है. We need to be very confident about self-assessment that is carried out. Carrying out self-assessment does not mean carrying it out accurately. Being truthful about self-assessment is completely different from being accurate about self-assessment. So therefore, as long as we have conducted the self-assessment truthfully, we have nothing to be anxious about. 90% of inspection and search proceedings are illegal for the reason tax officers who are conducting search proceedings don't know where is the evasion. So I was discussing with tax officers in officers training about inspection, search and seizure. And during the tea break, an officer came and said, "Sir, if we should know what is the evasion before we go for the inspection, how will we know this information?" अभी जाएंगे, वेरीफाई करेंगे, तभी तो पता चलेगा कि इवेजन हुआ है या नहीं. हाउ विल वी नो दिस इंफॉर्मेशन बिफोर हैंड? So I would bring all of us to consider the language of section 67, where the proper officer, not below the rank of joint commissioner, has reasons to believe that, which means the proper officer is not the investigating officer. The officer who is conducting the investigation is the delegate of the proper officer who is not below the rank of joint commissioner. And the joint commissioner should have reasons to believe. Reasons to believe is something more than suspicion and something less than evidence in possession. Reasons to believe is something more than suspicion, but something less than evidence in possession. Evidence in possession is required for section 64. Suspicion is sufficient for 61. But please bear in mind, reasons to believe is not one's own doubts. Reasons to believe is some material available on record based on which the joint commissioner, in looking at what reasons to believe, no less than a joint commissioner should be satisfied that some evasion has taken place. I feel you are not paying tax correctly. Is that evasion? It is feeling. If I look at you, I think you are not paying tax correctly. You are paying all your output tax through credit. You are paying all your tax. You have excess credit. Your credit is not matching. Friends, एक बात बताऊं. एक बार ऐसा हुआ कि हमारा एक कॉलेज का दोस्त अपने पसंद की लड़की के साथ शादी कर ली और पुणे में सेटल हो गया. जब कभी भी हम पुणे जाते तो वो जरूर घर बुलाता. और एक बार मैं पुणे जा रहा था, बताया उनको कि मैं पुणे आ रहा हूँ, तो ज़बरदस्ती बुलाए, आओ घर पे नाश्ता के साथ में करेंगे. तो घर गया तो भाभी ने एक बहुत अच्छा सा डिश बनाई. पहली बार मैं खा रहा था, उसको कहते पोहा. सुना हो पोहा? तो मैंने पोहा खाया, मीटिंग के लिए गया. 2 दिन बाद वापस जाना था, 8 बजे की फ्लाइट, 4 बजे को मीटिंग खत्म हो गया. तो मैंने कॉल किया, उसने कहा नहीं तुम जरूर घर आना. क्या है, इतना प्यार जता रहे हो? एक्चुअली उसको बेंगलोर कुछ भेजना था और मैं बस कुरियर था. तो घर पहुंचा, 4 बजे भाभी ने बनाई पोहा. पोहा बना, बहुत अच्छा था. 2 दिन पहले भी खाया था मैंने, बहुत पसंद आया. तो मैं पोहा खा के निकल गया. एक 3-4 महीने बाद हम सब कॉलेज दोस्तों का एक गेट टुगेदर हुआ. तो जाहिर है जब कॉलेज के दोस्त मिलते हैं तो जो वहाँ पे नहीं है उसके बारे में बात करते हैं. तो इनके बारे में बात शुरू हो गया और एक एक करके सभी ने बताया वो जब पुणे गए, घर गए और भाभी उनको पोहा खिलाया. तो ये सडनली अभी सीक्रेट बाहर आ गया. तो सब लोग फोन मिलाए, बात की उनसे, ये क्या है भाई? शुरू में तो वो तो एकदम स्ट्रिक्ट बता रहा था, लेकिन बाद में हमसे कुछ छुपा नहीं है क्योंकि बहुत सारे पुराने सीक्रेट्स भी हम सबको पता है. तो उसने कहा यार देखो, शादी तो मैंने अपनी पसंद की कर ली, लेकिन क्या है, भाभी को ना सिर्फ पोहा बनाना आता है. कभी कभार उनको इंस्पायर करने के लिए मैं काजू किशमिश लेके देता हूँ. भाभी काजू किशमिश के साथ पोहा बना देती है. द रीजन व्हाई आई एम सेइंग दिस फ्रेंड्स इज जीएसटी ऑफिसर को पता नहीं है कि कौन सा सेक्शन में कौन सा काम करना है. सेक्शन कोई भी दे दो, करेंगे वही. 2A नॉट मैचिंग 3B, R1 नॉट मैचिंग 3B, 17(5), 42, 43, यही करते रहते हैं. इट डज नॉट मैटर, काजू किशमिश ला के दो, करेंगे पोहा, और हम भी रोज पोहा खा रहे, रोज पोहा खा रहे। तो देयरफॉर फ्रेंड्स प्लीज बी वेरी केयरफुल। जीएसटी में सबसे मजबूत सेक्शन जो है वो है सेक्शन 59, छोटा सा सेक्शन है, कहते हैं एवरी रजिस्टर्ड पर्सन शैल सेल्फ असेस द टैक्स लायबिलिटी। अगर मैंने असेसमेंट कर ली तो ऑफिसर क्या देखने वाले हैं? व्हाट कैन ऑफिसर सी? ऑफिसर इज हैविंग लॉट ऑफ क्वेश्चंस। AS70 10 मतलब एकदम बाढ़ जैसा आ रहा है। AS70 10 एक ने तो ADT 2 में ADT 2 आ गया, ADT 2 के अगेंस्ट उन्होंने अपील फाइल कर दी। लो कर लो बात। ऑडिट हुआ, ऑडिट के रिपोर्ट मतलब उसके लैंग्वेज को देख के सामने वाला डर गया, अपील फाइल कर दिया। जॉइंट कमिश्नर ने अपील को एडमिट भी कर लिया और उन्होंने कहा डोंट वरी, मैं I will give you justice. Please bear in mind, officers of the law are not the gatekeepers of justice. Officers of the law must follow the procedure. Justice will take care of itself. Please bear in mind, टैक्स पेयर को जब नोटिस आता है, बेंगलोर की बात कर रहा हूं, रोकेला का पता नहीं क्या है, वहां पे सबसे पहले टैक्स पेयर कहते हैं सर आप इसको सेटल कर दो। पता सेटल कर दो का मतलब आप जानते हो कि नहीं, मुझे पता नहीं है। रोकेला में क्या क्या कहते हैं इसको? वही वन नेशन वन टैक्स। एक्सेलेंट फ्रेंड्स, प्लीज बेयर इन माइंड, वी मस्ट नो आवर राइट्स, रेमेडीज एंड सेफगार्ड्स इन द लॉ। टैक्स ऑफिसर कैनॉट आस्क क्वेश्चंस unless there is a specific section. 61 is one door to enter the taxpayer's records. 65 is the next door. 67 is the third door. Only 3 doors. 61, 65, 67. Inspection search seizure can take place only in 67. लेकिन वो आएंगे, देखेंगे, finally they will come to 2A is not matching 3B, R1 is not matching 3B, 42, 43, 17, 5, falan, falan. Please bear in mind, the central theme sits in section 67(1)(a). We'll read what 67(1)(a) says, where the proper officer not below the rank of joint commissioner has reasons to believe that A, taxpayer has suppressed supply, suppressed stock, claimed credit more than entitlement, contravened act or rules to evade payment of tax. Please bear in mind, only for 4 things they can come. Only for 4 reasons they can come. 2A, 3B is not here, 17(5) is not here. लेकिन क्या है, भाभी को बनाना आता है सिर्फ पोहा। हाँ, हमें आजकल पोहा पसंद आना भी लग गया। We are also cooperating in all these things. So therefore, please bear in mind, only 4 things. The reasons to believe must be one of these 4 things are taking place. I give a small example. Officer gave notice, R1 is not matching 3B. R1 is not matching 3B. Reply file किया. Reply file किया. GSTR 9 has already been filed. शादी हो गया, लड़का एंगेजमेंट के सूट के बारे में कंप्लेन कर रहा है। 9 फाइल हो चुका है, 1 और 3B को लेके करेंगे तो क्या करेंगे? Nothing can be done. But friends, please bear in mind, we are used to giving long answers. अब बीकॉम के डेज में देखो या LLB के डेज का सोचो, एक्स्ट्रा आंसर पेपर लेके हम आंसर लिख के आए, नंबर मिला 42, पेपर में नंबर मिला 42, लेकिन लिख के आए 50 पेज। Somehow we think that if you write a very long answer, it will be convincing. My submission is, if the answer is long, it's most likely wrong. अगर बोलने लायक 4 बातें हैं तो 2 पन्नों में कहा जा सकता है, 40 पेज का जरूरत नहीं है। जब कहने को कुछ नहीं है तो 40-50 पेज लिख देते हैं। प्लीज बेयर इन माइंड, अंडरस्टैंड योर राइट्स, रेमेडीज एंड सेफगार्ड्स। टैक्स प्रोफेशनल्स की अभी पोजीशन ऐसे हो गई है, मैं ब्लड टेस्ट कराने लैब गया था। I had gone to take blood test for me for insurance policy to the lab. वहाँ पे मेरा एक एडवोकेट फ्रेंड मिल गया। अरे क्यों आए भाई? नहीं क्या हुआ, मेरे क्लाइंट को ना ब्लड टेस्ट कराना था। हाँ तो तुम क्यों है? मेरे क्लाइंट है, मैं अपना खून ही दे देता हूं, क्या फर्क पड़ता है? हैं? शुगर ऊपर नीचे करीब करीब सेम रहेगा। हैं? उनका टेंशन मैं जो ले रहा हूं। हैं? प्लीज बेयर इन माइंड व्हाई टैक्स प्रोफेशनल्स आर अटेंडिंग समन्स। व्हाई टैक्स प्रोफेशनल्स आर अटेंडिंग समन्स? सेटल करने की कोशिश, सेटल कर। प्लीज बेयर इन माइंड only evasion gives jurisdiction to the proper officer to issue authorization. So therefore, please ask yourself every time someone says they have come to inspect, don't stop them. Let them do, let them search, let them check what they want to check. You are BCom, he is BA. Be calm. He does not know what to check. He will still search everything and find out what? 2A is not matching 3B, R1 is not matching 3B, 42, 43, 17. That's all he will do. You understand? So therefore, please be very careful. कहीं जवाब देते देते कहीं हम उनके केस को साबित ना कर रहे। How many have received notice that 26AS is not matching ST3? Everybody. आजकल तो बेंगलोर में एडवोकेट्स को भी दे रहे। 26AS is not matching ST3. Now 26AS is not matching 3B. Please bear in mind, short reply, 26AS is not supposed to match ST3. When you look at evasion of tax, we must understand what is evasion. Every non-payment of tax cannot be evasion. Every non-payment of tax cannot be evasion. I would sense there are 4 ingredients for something to be evasion. Non-payment of tax, knowledge of liability, मतलब हम जानते हैं कि टैक्स भरना है लेकिन भरे नहीं है। थर्ड, कंसीलमेंट ऑफ इंफॉर्मेशन, उस इंफॉर्मेशन को कुछ एक चीज करके वी हैव कंसील्ड दैट इंफॉर्मेशन एंड देन देयर इज सम बेनिफिट बाय डूइंग समथिंग लाइक दिस। हमने भरा 12%, वो कहते हैं 18 भरना था। वेयर इज द इवेशन? एवरी नॉन पेमेंट इज नॉट इवेशन। नो, यू आर सपोज टू नो the GST properly, you have not paid the GST. Friends, please bear in mind, 90% of inspection proceedings are illegal, 100% of illegal investigations we are cooperating. If you look at summons, the language of section 70 is very clear. The language of section 70 is very clear. Whenever an inquiry is going on, summons can be issued. When evasion is taking place, Joint Commissioner has to give permission. But for summons, Deputy Commissioner can issue summons. Please bear in mind, summons is a assistant to 67. 70 is not a standalone provision. 70 is going to assist proceedings under 67. 70 cannot exist independent of 67. Audit officer, jurisdictional proper officer should not be issuing summons. Friends, please bear in mind, we are completing an incomplete investigation. ऑफिसर ने कहा तुम्हारा 2A 3B के साथ मैच नहीं कर रहा है। Your 2A is not matching 3B. हाँ तो किसका मैच हो रहा है? किसी का मैच हो रहा है? Please raise your hand. Anybody's 2A is matching 3B? वो नोएडा और सूरत वाले हैं। जिनका 2A 3B के साथ परफेक्टली मैच हो रहा है, क्योंकि दुकान में बैठ के हो रहा है वो बस मैचिंग। बिजनेस में कुछ नहीं है, पूरा बिजनेस पेपर वर्क है। हमारा तो बिजनेस है, साथ साथ मैचिंग भी करना है। प्लीज बेयर इन माइंड, जस्ट बिकॉज समथिंग इज नॉट मैचिंग डज नॉट मीन यू आर रॉन्ग। वी आर नॉट कॉन्फिडेंट। तो ऑफिसर ने कहा योर 2A इज नॉट मैचिंग 3B, तो स्टैंडर्ड रिप्लाई, व्हेन द आंसर इज लॉन्ग इट्स मोस्ट लाइकली रॉन्ग। Short reply, short reply. So, what has to be done? Do the reconciliation. आता नहीं। Knowledge is to know what to say. Wisdom is to know when to say. Those who have had more than 20 years of happy married life, you will agree with me. Those who are laughing are the ones who have successfully use this method to know when not to speak. Please bear in mind, if 2A is not matching 3B, what does it mean? It means somebody else has not filed returns properly. पहले उनको पकड़ो, काम करो, मेहनत दिखाओ, फिर देखते हैं कि whether my credit is mala fide or bona fide. Please bear in mind, just because two things are not matching does not lead to any adverse inference. But we are not, वो कंट्रोल ही नहीं हो रहा है. रिकंसिलेशन करते करते जिंदगी निकल गई कि कुछ भी दे दो रिकंसाइल करके पकड़ा देंगे. मैंने यहां तक देखा कि किसी ने डेटर और क्रेडिटर के साथ रिकंसाइल कर दिया. तो टैलेंट देखो, इतना ज्यादा है, कर देंगे. डेटर को क्रेडिटर के साथ कर दिया रिकंसाइल, और हर रीजंस भी है, एकदम बहुत इंप्रेसिव रीजंस. फ्रेंड्स, प्लीज बेयर इन माइंड, who has to prove the case? Who has to prove the case? We take a few principles. Arpit ji mentioned about evidence law. The one who makes the allegation has the burden to prove the allegation. Simple si baat. The one who makes the allegation has the burden to prove that allegation, but why is the assessee taking the proof on subcontract basis? ठेका ले रखा है. We want to do the reconciliation. We want to prove our innocence. क्योंकि टैक्स पेयर को क्या है? He does not want litigation. Taxpayer does not want litigation. किसने कहा? Who said taxpayer does not want litigation? I will give you three kinds of clients. One client, he has done everything correctly and he has got notice. क्या ये litigation करना चाहेगा? सब कुछ ठीक ही है, लेकिन फिर भी उनको नोटिस आया है. Will he litigate? Of course he will litigate. एक ये जानते हुए कि दो इंटरप्रिटेशन है, उन्होंने एक कोई इंटरप्रिटेशन को अपनाया है. Whether he will want to litigate? Of course he will also litigate. दूसरा कुछ गपला किया है. Whether he will litigate? Of course. Who is this client who does not want to litigate? बताइए. Please bear in mind, पेशेंट सर्जरी के लिए जब करना पड़ता है, वो डॉक्टर के नजर आंखों में कॉन्फिडेंस देखना चाहता है. द पेशेंट हैज टू सी कॉन्फिडेंस इन द डॉक्टर्स आइज. यहां सिचुएशन ऐसा है कि जब नोटिस आ जाए, हमारे दोस्त फोन कर देते हैं, तो नोटिस आ गया. जैसे नोटिस आ गया, अच्छा कौन सा सेक्शन में, देखा नहीं है, ब्राउन कलर कवर आया है, फोन मिला लिया. देखो तो सही क्या है उसके अंदर. हाँ ADT 1 है, नोटिस है क्या ये? डॉक्टर का परिस्थिति अभी ऐसा हो गया है कि पेशेंट का हाथ टूटा हुआ है, रोना डॉक्टर साहब को आ रहा है. हमदर्द, यहां तक इतना हमदर्दी. प्लीज बेयर इन माइंड, notices will be issued. Everybody will get notices. During Corona, many of us have got affected. Many of us were very badly affected with someone very close to us also. But today, with God's grace, we are all here. Corona को पार करके आ गए. How many members here did not get Corona? Please raise the hand. सर ने कहा लंच के बाद चैलेंज है, वो चैलेंज को हम टैकल करेंगे. देखिए कंफ्यूजन कितना है ऑडियंस में. दुनिया में दो टाइप के लोग हैं. एक जिनके पास टेस्ट रिपोर्ट है, दूसरा जिनके पास रिपोर्ट नहीं है. कोरोना तो सबको आ गया. यही तो प्रोग्राम भी था कि आए लेकिन एक साथ ना आए. प्लीज बेयर इन माइंड, एवरीबडी विल गेट नोटिस. अगर कोई है यहाँ जो सोचते हैं कि हमको नोटिस नहीं आया, आप लॉगिन चेक करो, आ चुका होगा. एवरीबडी विल गेट नोटिस. क्योंकि नोटिस देने के लिए सामने वाले को मेहनत करना ही नहीं है. 2A इज नॉट मैचिंग 3B, दे दो. एक तो नोटिस ऐसे आ गया कि 2A इज मोर देन 3B, 3B is more than 2A. चलो नोटिस समझ में आ सकते. 2A is more than 3B. That means unaccounted purchase, that means unaccounted sales. और वो भी 35% GP. पूरा देश 4% में ग्रो हो रहा है. सिर्फ मेरे क्लाइंट मंथली 20% ग्रोथ हैं. 2 साल में ये अदानी को कंपटीशन देगा. So please bear in mind, there is no intelligence being used to arrive at a conclusion that there is loss of revenue, because we are ready to do the reconciliation. My submission is, please be very vigilant. Is there evasion? Then only inspection is permitted. If there is no evasion, there is no question of inspection. Next, they will do search. What should we do? You don't do anything. They will do search. Nothing taxpayer needs to do. I want to invite your attention to certain aspects of section 67. Whatever the department wants to do, please cooperate. Let them do whatever proceedings they want to do. Everything has to conclude with a show cause notice. Everything has to conclude with a show cause notice. After show cause notice, before replying to show cause notice, one very important step. After show cause notice, before replying to that show cause notice, one very important step, section 6710. The section is very brief. It says, Commissioner shall take the place of magistrate under section 165(5) of CRPC. Please bear in mind, when any proceeding under 67 is initiated, the safeguard for the taxpayer is 6710. So you please wait till you get show cause notice. After you get show cause notice, make an application under section 6710 demanding disclosure of investigative material. Demanding disclosure of all investigative material, and now you can sit, itminan se baith ke you can examine what happened. What happened? How did they start the investigation? What was the purpose for giving authorization in INS 1 under Rule 139? And what was the evasion they started to investigate? Where did they end? Kaju kishmish poha ban gaya. Please bear in mind, 6710 is the safeguard for taxpayers, and I don't know how many cases we are making this application. Sawal milte hi jawab dena shuru. So my submission is, before you launch into answering the question, please pause and question the question. Is the question correctly raised? We are so interested in giving the answer that we don't want to wait till the question is properly appreciated, because if the wrong issue is raised under 67, then the entire demand is tainted. There is no reason to proceed with the demand. Please bear in mind, we need to avail the safeguards given by the statute. If we are not interested, then nobody can come to such a taxpayer's rescue. So therefore, make this application under 6710, and I'm telling you, in 9 out of 10 cases, you will not get a reply. When they don't give you a reply, which means they don't have a reply. Do you think they have the information and they're not giving? No, they don't have any information. No reasons to believe. CIT versus S. Narayanappa in 1958 AR Supreme Court said, reasons to believe is not doubts and suspicions. It is a conclusion reached by application of mind. What was applied, what was examined, what was the application of mind to come to this conclusion that there is evasion? When you look at evasion, friends, please be very careful. Look at this provision in 67(1)(a). Stock is suppressed. What is the meaning of stock is suppressed? I have sold but not reported the supplies. So what is here? एक लड़का ड्राइंग क्लास में बैठ के ड्राइंग कर रहा था. टीचर ने सबसे कहा, देखो भाई सब अपना अपना ड्राइंग करो, मैं आके चेक करता हूं. एक लड़का है जो बाद में जाकर के टैक्स कंसल्टेंट बन गया, तेज था, वो एक ब्लैंक पेपर लेकर बैठा था. हाफ एन आवर बीत गया, टीचर आए, पूछे, बच्चा तुमने क्या ड्राइंग किया? सर मैंने ड्राइंग किया बस स्टॉप. बस स्टॉप. लोग कहाँ हैं? यहाँ तो लोग ही नहीं है. लोग कहाँ हैं? सर सारे लोग तो बस में चढ़ गए. अच्छा बस कहाँ है? वो तो चली गई. So please bear in mind, what are you seeing in the notice? सबको कुछ ना कुछ नजर आ रहा है. We have to be very careful to identify how do you prove stock is suppressed. यहाँ बीकॉम वाले डबल एंट्री में डगमगा रहे हैं, वहां आर्ट्स के स्टूडेंट सप्रेस ऑफ स्टॉक नोटिस दे दिए. प्लीज बेयर इन माइंड, allegation without evidence is imagination. Allegation without evidence is imagination. Allegation not disputed become fact. allegation without evidence is imagination, but allegation not disputed become fact. Section 58 evidence law, where you don't dispute it. When something is undisputed, where is the need for proof? 2A is not matching 3B. हाँ ये देखो reconciliation. You have paid royalty on mining activity. You have not paid RCM. अच्छा, proof क्या है? You have not paid. नहीं, proof बताओ. You have not paid. 4 बार बताने से वो proof नहीं बन जाता. Proof किसको करना है? Proof किसको करना है? Please examine all these royalty cases. Total amount of cash payment, whether output tax or RCM, total value of challan. If it is more than your RCM liability, तो मेरा मानना है कि आपने RCM भर दिया. आपको अंदाजा नहीं है, लेकिन आपने भर दिया. भर भी दिया और ITC भी ले लिया. नहीं, तुम्हारा 3 भी गलत है. Please raise the hand and tell me how many have filed perfect 3B. Nobody. These are experts. एक ने भी फाइल नहीं किया परफेक्ट. अच्छा, तो 3B कौन सा एविडेंस बन गया? नहीं. If you don't dispute the allegation converts into a fact. Please be very careful. Ask yourself whether the allegation is substantiated with evidence or not. When you talk about evidence, the question arises whether summons, statement made in summons is evidence. बुलाए किसी को, पूछे 4 सवाल, उन्होंने कुछ आंसर दे दिए और वो एविडेंस बन गया. If you look at section 136, there is no evidentiary value for statements made. समन देते कंपनी के डायरेक्टर को, मैनेजिंग डायरेक्टर को समन देते, सही बात है ना, एमडी को समन देते. एमडी को क्या पता, मतलब क्या पता, तभी तो उनको एमडी बनाए. और खास तौर से जीएसटी के बारे में उनको क्या पता. When you look at statements recorded in summons, please examine whether their answers given is a fact or an interpretation of the fact. Summons में जो statement दी जाती है, is it a fact or is it an interpretation of the fact? Fact वो होता है जिसके बारे में कोई दो राय नहीं है. Are you registered? Are you not registered? Do you supply? Do you not supply? Did you sign this contract? Did you not sign this contract? ऐसे फैक्ट को समन में रिकॉर्ड करने की जरूरत क्या है? अगर फैक्ट को लेकर के इंटरप्रिटेशन करना है तो उसका वैल्यू क्या है? डू यू अग्री दिस इज अ टैक्सेबल सप्लाई? यस सर. यहां पे एक्सपीरियंस्ड एडवोकेट्स, चार्टर्ड अकाउंटेंट्स आर डिबेटिंग दैट इट इज नॉट क्लियर इन द लॉ. लेकिन वो आईआईटी के इंजीनियर है, एमडी, उन्होंने हाँ करके आ गए, हाँ आई थिंक इट इज टैक्सेबल. सही बात, क्लैरिटी के साथ आप तो समझा दिया. हु इज द फाइनल अथॉरिटी? वो एसआईओ, सीनियर इंटेलिजेंस ऑफिसर, वो सुप्रीम कोर्ट है. सुप्रीम कोर्ट कहते हैं कभी कभी हमको कंफ्यूजन हो जाता है. कितने तो ऐसे इश्यूज है जो सुप्रीम कोर्ट हैज रिवाइज्ड इट्स इंटरप्रिटेशन. सो हाउ कैन एसआईओ थिंक दैट द लॉ इज वेरी क्लियर? सो प्लीज बेयर इन माइंड, स्टेटमेंट is not a reliable source of evidence. एक बात बताऊं, हमारे बुक्स ऑफ अकाउंट्स हैं, ऑडिटेड बुक्स ऑफ अकाउंट्स, इज इट ए रिलायबल एविडेंस? आवर बुक्स ऑफ अकाउंट्स, इज इट ए रिलायबल एविडेंस? सेक्शन 34, प्लीज क्लाइंट से बताना मत, वरना अकाउंटिंग का असाइनमेंट निकल जाएगा. सेक्शन 34 ऑफ एविडेंस एक्ट सेज बुक्स ऑफ अकाउंट्स आर नॉट ए सोर्स ऑफ रिलायबल एविडेंस unless it is corroborated. तो एमडी का दी हुई स्टेटमेंट का क्या वैल्यू? तो मैं तो कहता हूं जाओ, सम्मन आता है तो जाओ, जो मन में आए बोल के आ जाओ, जो मन में आए बोल के आ जाओ. क्या वैल्यू है? कोई वैल्यू नहीं. प्लीज बेयर इन माइंड, अगर पूरे डिमांड शोकॉज नोटिस पे किसी के स्टेटमेंट पे कायम है तो उससे बढ़िया असाइनमेंट दूसरा कोई नहीं हो सकता. Please bear in mind, all inspections will conclude with a show cause notice. जीएसटी में स्पॉट रिकवरी होता है, आए दबाव बना के रखे और डिमांड कर लिए और पेमेंट भी हो गया. मैं टैक्स पेयर से 3 बातें कहता हूं जब सर्च होता है. 3 बातें. फर्स्ट, Don't agree to any interpretation of law. Don't agree to any interpretation of law, क्योंकि expert मैं हूं, तुम नहीं. तुम client हो, मैं expert. Don't agree to any interpretation of law. Second, don't agree to make immediate payment. Don't agree to make any immediate payment. 3, don't ask for installment payment plan. ये settlement वाले अभी EMI पे आ गए. Don't ask for installment payment plan. नहीं सर, वो ट्राई किया लेकिन 11 बज गया रात को, बोले बिना रिवर्स किए तुम जा नहीं सकते, अरेस्ट कर देंगे, अरेस्ट कर देंगे. सेक्शन 69 अगर आप देखेंगे, अरेस्ट के लिए कमिश्नर का वारंट निकलना जरूरी है. इससे शर्मनाक बात कोई और नहीं हो सकती है कि वारंट इशू हो गई और ऑफिसर अरेस्ट करने गए और खाली हाथ आए. वो ऑफिसर तो पूरे डिपार्टमेंट में वर्ल्ड फेमस हो जाएगा कि वारंट एग्जीक्यूट कर नहीं सका. जब अरेस्ट करना होता है कैसे करते हैं? हाँ, वो स्विगी वाले केस में हमने देखा है, बुलाए डिपार्टमेंट को, बिठाए, फिर चुपके से दरवाजा बंद कर दिया. अरेस्ट वैसे होता है, वरना फरार होने का चांस है. प्लीज बेयर इन माइंड, जब कहते हैं कि अरेस्ट करेंगे, नहीं करेंगे. करने वाले बताते नहीं हैं, बोलने वाले समझ में आ गया. सो देयरफॉर क्लाइंट ने कहा नहीं सर, बोल दिया कि अरेस्ट तुरंत अभी के अभी कर देंगे 11 बजे को, तो मुझे जबरदस्ती पेमेंट करना पड़ा, जबरदस्ती पेमेंट करना पड़ा. तो मैं हमेशा क्लाइंट से कहता हूं, देखो हो गया पेमेंट, अभी मंडे को ऑफिस आ जाओ, क्या करना है? RFD1 फाइल कर देंगे, क्योंकि RFD1 इन्वेस्टिगेटिंग ऑफिसर के कंप्यूटर तक नहीं पहुंचता, वो जाएगा ज्यूरिसडिक्शनल ऑफिस, वहां पे RFD2 लेके आ जाओ. RFD2 लाने के लिए टैलेंट का जरूरत है, वरना RFD3 दे देंगे. RFD2 लेके आ जाओ, पैसा सेफ है. अभी देखिए, कैश में जमा करेंगे तो वो पैसा सेफ है, ITC में रिवर्स होगा. अगर रिफंड सैंक्शन हुआ तो क्रेडिट लेजर में वापस 86(4)A, अगर रिजेक्ट हुआ तो भी वापस 93 PMT 03. So therefore, please bear in mind, we have to be very careful about what steps need to be taken. यहां तक के एक SOP बन गया, सर्च हो रहा है, ठीक है मंडे को बात करते. नहीं सर, तुरंत बात करना है, मंडे को बात करते हैं, रूरकेला जा रहा हूं, मंडे को बात करते. नहीं सर, ऑफिसर फोन पे फोन किए जा रहे हैं, मंडे को बात करते. देयर इज नो नीड टू गेट एंग्शियस, क्योंकि क्या है, ये हमदर्दी जताते जताते एडवोकेट खुद खून देने आ गए लैब में, पेशेंट गया ऊटी मनाली. प्लीज बेयर इन माइंड, डिमांड टैक्स पेयर की है, हम बस अपने सर्विस कर रहे हैं. वी आर ओनली गिविंग आवर सर्विस. हाउ मेनी प्रोफेशनल्स हियर हैव फ्रेंड्स इन द डिपार्टमेंट? नोबडी. मतलब आप उनका मोबाइल नंबर आपके मोबाइल में सेव्ड, आपका मोबाइल नंबर उनके मोबाइल में सेव्ड. फोन आएगा तो इमीडिएटली वो ये नहीं कहेगा डिपार्टमेंट, वो कहेगा मिश्रा जी हमारे मोबाइल में, इज्जत के साथ. प्लीज बेयर इन माइंड, एज प्रोफेशनल्स वी हैव ग्रोन to build a relationship with the officer because the law was not on our side. We have learned to build a relationship with our officer, but I only want to say, friendship and relationship with an officer is an unholy association. दोनों में से कोई ना कोई मौका के लिए वेट कर रहा है दूसरे का फायदा उठाने के लिए. या तो मैं कहूंगा सर हमारा क्लाइंट है, रिफंड आप सैंक्शन कर दो, शाम को मिलेंगे. या ऑफिसर कहता है इस महीना मेरा टारगेट है ना, तुम तुम्हारे क्लाइंट से बोल दो कि जमा कर दे. अनहोली एसोसिएशन. हाउ मेनी बिलीव योर क्लाइंट्स आर वेरी लॉयल टू यू? प्लीज रेज योर हैंड. अगेन नोबडी. बट वी आर इंटरप्रेटिंग द लॉ प्रो असेसी. मतलब सेक्शन खोलते हैं, इज इट टैक्सेबल? कल किसी से बात कर रहा था, मैंने कहा उनसे देखो ये अमेंडमेंट जो आ गया पढ़ा तुमने? नहीं पढ़ा. वो तुम्हारे क्लाइंट को अफेक्ट करेगा? नहीं करेगा. क्यों नहीं? वो क्लाइंट को अफेक्ट न करेगा. नहीं, क्यों नहीं करे? कोई ना कोई वजह निकलेगा, लेकिन करेगा नहीं. ITC मिल सकता है कंस्ट्रक्शन पे? हाँ मिल सकता है. कैसे? पता नहीं यार, मिल सकता है. इस पे एग्जेम्पशन मिलेगा? मिल जाएगा. कैसे मिलेगा यार? वो सुप्रीम कोर्ट मिल जाएगा यार. हम सोचते हैं हमारी लॉयल्टी या तो ऑफिसर के प्रति होना चाहिए या क्लाइंट के प्रति। मैं समझता हूं हमारी लॉयल्टी लॉ के प्रति होना चाहिए और हमारे क्राफ्ट जो काम करते हैं उसके प्रति होना चाहिए। कोई लॉयल्टी की जरूरत नहीं है, लॉ के साथ लॉयल्टी रखो। एंड आई थैंक ऑल ऑफ यू फॉर making time to be here in this conference, because this is a place where all the stalwarts are here, and we will take back something that will change the way we practice GST. Thank you all very much.
Thank you, sir, for making the session so interesting. May I please invite Session Chairman Advocate Pankaj Ghia to please give his concluding remark.
Sometimes I wonder what to do about after search, whether it is illegal, whether it is illegal, whether it is correct, whether it is incorrect. But that cannot be decided by you. You can only file a reply or only litigate it. If you want to say that the search is illegal, you have to go to the High Court. Otherwise, you have to go to the routine rigmarole of filing of reply, show cause notice, order, appeal. First appeal is the department, no issues. Tribunal, not yet made, no issue. Continue with litigation. Continue to pay 10% first. If you are so strong that you are not able to pay or adhere to the demands of the officer not to pay something by DRC 03 or otherwise. If you pay by DRC 03, no appeal. Now, those are the situations which we have to understand. Those are the things which we have to see. If you have a iota of doubt that he has not followed a provision of law, go to the High Court. Maybe you have 20% chance of success. 80% chance is that High Court will maybe admit but not stay. Maybe issue notice but not stay, or maybe dismiss it. But then again at the second stage, again go to the High Court. But then again it has to be seen what are the quantums. What is the amount involved? If it is a petty amount, if it is a small amount, if the dealer do not want to litigate, let him not litigate. I agree with Jatin ji that we should do our work not with the heart but with the brains. Have you ever seen a doctor, if he is a client, he will not charge you his fees, but for the test he will write 2,000 rupees of test. His fees is automatically there. So, search. Now in the GST there is a new concept. Don't issue the show cause notice. Before issue of show cause notice, press the client so hard that it automatically deposits the majority of the amount. He will push the client, he will make the pressure on the client, he will make the pressure on the consultant. Litigation lawyers like me, we don't care. We tell the commissioner or the officer, bullshit, whatever you want to do, do it. We will not ask the client. But if you are in a B class, C class town, the situations are different. It is the thumb rule which cannot be applied in all circumstances. I will say, friends, in search, it is a subject which needs the master speakers from all spheres. Because if a search is there, the illegality cannot be judged at that time. The statement taken on section 70 cannot be judged on that time. I was arguing a bail petition in the High Court. The department was saying, sir, he has given a statement under section 70. He has done this, done this, done this. I told it is a section 70 statement and not akin to 164 statement. It is a statement in a police station. we don't rely, it is under coercion pressure. The Supreme Court guidelines of recording and CCTV and not followed. But then the court do not go into those type of things. Retraction of a statement. If a statement is taken, maybe under pressure, not under pressure. If you have said right or wrong. But if you had said wrong, sometimes what to do, whether the retraction has been made or not. Jatinji has said one thing, if a person goes, we tell him go and give a statement, whatever. See, a person does not want to go to the department to give a statement only in two circumstances. One is either is evasion or the so-called evasion or the alleged evasion is more than 3 crores. You will tell Pankaj ji arrest to 5 crore pe, why 3 crore? From 3 to 5 they can make it. And then the fear of arrest comes into picture. So, if the amount is 1 crore, 20 lakhs, 50 lakhs, 10 lakhs, you go and say anything. The officer cannot do anything. He will do one thing only. And they are now experienced for that. He will call you at 11, make you to sit up to 5, take your statement from 6 o'clock, make you to sit up to 9. And what Jatinji has said, rightly said, I will arrest you, I will do this, I will do that. Previously, when it was the wet times, we always wanted to say, go to the department at 3 o'clock. Because at 5 o'clock, the officer wants to go home. Now the scenario has changed. The officers are willing to sit up to 10, 11 o'clock in the night. They know how to pressure you, how to coerce you to give a statement. They will call you today, make you sit throughout the day, again call you tomorrow, make you sit throughout the day. If they can call Rajiv Gandhi, Rahul Gandhi, if they can call Lalu Prasad, if they can call other things. So ED and GST, the provisions are, I would not say peri-materia, but they know you can call for summons 3 times, 4 times, 5 times. If you do not agree, the only remedy is to the High Court. If you do not go, it is a non-compliance. So friends, practical aspects has to be seen. What to do, whether to challenge, what are the mistakes, retractions, the litigations, how to take the pressure of the payment, because nowadays what we are doing as litigation lawyers, we are asking letters to them or sending letters to commissioner saying that everything is complete, every data is complete, but he is not issuing show cause notice. Once the SCN is issued, everything is finished. Only then the 10% liability comes of the tax amount. They also know it. And issue of SCN is akin to issue of assessment order or the adjudication order. Lot of things are there, time is short, but I can say these are the eye-openers which Jatin Bhai has said, and you have to follow. The litigation, 90% of the search is illegal. I totally agree with him. The 67 rigmarole is something which we have to understand. 70 summons, we go to the various courts, not a favorable decision till now from any of the court. The litigation would continue. More the litigation, more merrier for us. Let it be continued and let us see in the next meeting. Thank you.
Thank you, sir. There's a question for Advocate Jatin from the audience. If you could come forward, sir. Okay.
Sir, my first basic question is, what is the difference, basic difference in between INS 02 and 03? Can they or they are competent to issue on the spot, INS 2 or 3, on the basis of 1. Clearly, 67(1)(a) clearly says, 67, INS 1 says for inspection only, for seizure and search and seizure. There is a specific INS 02. INS 02 is available with the visiting officer instantly, and they issue instantly 2 and 3 also. So what is the basic decision? Can they are competent to issue 2 and 3, and more interestingly, they issue someone under section 70 on the spot, on the basis of INS 1, or INS specifically says for inspection only. Can they seize or seizure, make seizure?
See, INS 1 has 3 parts to it, sir. Part A, B, and C. Part A deals with taxable person's premises to be inspected. Part B deals with any other person whose premises is to be inspected. Part C deals with 67(2). The Joint Commissioner will give permission in A and C. So therefore, the investigating officer already has authorization in Part C to conduct search of offending goods, documents, books and things if they are secreted. The moment he finds something is secreted, he is required to seize them. INS 2 is for seizure, INS 3 is for prohibition order. So therefore, the power to seize or issue prohibition order flows from Part C to INS 1. So therefore, it is allowed. And once inspection is authorized, investigation is commenced. That's a prerequisite to give summons under 70. So it is permitted because of INS 1. It's permitted, sir.
I think that's all. So now we will move on to the felicitation ceremony of session chairman and session speaker. May I invite Advocate Pradosh Patnaik to please come forward to felicitate Advocate Pankaj Ghia. Advocate Pradosh Patnaik. May I call upon Advocate Pradeep Yadav to do the honors, please? Ladies and gentlemen, we will be felicitating our National President, Advocate Pankaj Ghia. The other one. Sorry for the little mix-up here. Advocate Pradeep Yadav felicitating Advocate Pankaj Ghia with a shawl and a memento. Thank you. May I request Advocate Pratap Chandra Rath to please come forward to felicitate CA Jatin Christopher. We have Advocate Pratap Chandra Rath coming forward to felicitate CA Jatin Christopher. We will felicitate Shri Jatin with a shawl followed by a memento. Thank you so much for coming, sir. This session was indeed very, very interesting. Give a big hand for session speaker, Jatin Christopher. Thank you. Thank you, sir. Thank you, sir. We'll pack it for you. We will now have a ceremony, a felicitation ceremony for the senior members of ROURKELA Tax Bar Association. We begin with the ROURKELA Tax Bar Association senior member, Anand Kumar Agarwal. I invite Advocate Pankaj Ghia sir, our national president, to please felicitate Advocate Anand Kumar Agarwal. May I please request his son to come forward and accept the felicitation on behalf of his father, Anand Kumar Agarwal. We will also invite the next recipient for this felicitation, Shri Bankim Chandra Patel. Advocate Bankim Chandra Patel will be felicitated by Advocate Narayan Jain. Okay. Next we have Advocate Binapani Padia, who will be felicitated by Advocate Ragini Goel. Binapani Paria is not there. Okay, sorry. May I please invite Advocate Gokul Chandra Patri. Advocate Gokul Chandra Patri will be felicitated by Advocate Pardosh Patnaik and Advocate Garima Patri. Advocate Garima Patri is the next in the family. Gokul Chandra Patri sir will be felicitated by Advocate Pardosh Patnaik and his daughter Advocate Garima Patri will also be joining in this felicitation. May I please invite Garima Patri madam to come forward. It is always a pleasure to see someone in the family being groomed as a successor. Please give a big hand for Advocate Gokul Chandra Patri being felicitated with a shawl followed by and a proud daughter standing beside. Next I invite Shri Hari Ram Agarwal. Advocate Hari Ram Agarwal to be felicitated by Advocate Sudhanshu Shekhar Das. And I also invite his son, Advocate Sanjay Agarwal. We will be felicitating Shri Hari Ram Agarwal. I've invited Advocate Sudhanshu Shekhar Das. Grandson. And the grandson also is invited. I'm sorry I did not follow the name. Grandson of Shri Hari Ram Agarwal to please join. He's not there. Okay, in the hall. Okay. Advocate Sudhanshu Shekhar Das felicitating Advocate Hari Ram Agarwal with a shawl and a memento. Thank you so much, sir. You're indeed an inspiration for the next generation. I invite Shri Lalan Prasad Singh for the felicitation, and to felicitate I invite Advocate Rabindranath Pal. Shri Lalan Prasad Singh, along with his son Advocate Gudakesh Singh, will be felicitated by Advocate Rabindranath Pal. May I please invite Advocate Karthik Kurmi, sir, to please come forward to felicitate Advocate Lalan Prasad Singh. Please come forward. Ladies and gentlemen, please give a big hand for Advocate Lalan Prasad Singh being felicitated by Advocate Karthik Kurmi and a proud son standing beside his father. Thank you so much. Thank you so much. I invite Ramakrishna Mishra, Advocate Ramakrishna Mishra, to please come on the dais for the felicitation. And I invite Advocate Bibekananda Mahanti to please felicitate Advocate Ramakrishna Mishra. Is Advocate Bibekananda Mahanti present in the hall? Okay, he's coming forward. He's coming. He's there. Ladies and gentlemen, Advocate Bibekananda Mahanti coming forward to felicitate Advocate Ramakrishna Mishra. We are presenting a shawl to Sir along with a memento. Congratulations, sir. Next, I call upon Advocate Radhe Shyam Agarwal ji. Advocate Radhe Shyam Agarwal ji to please come on the dais. He will be felicitated by Advocate Padmanabh Dave. I invite Advocate Dilip Agarwal to please do the honors. Conference Secretary, Advocate Dilip Agarwal, to felicitate Advocate Radhe Shyam Agarwal. Please give a big hand for the felicitation. A shawl and a memento to be presented to Advocate Radhe Shyam Agarwal for his services towards the ROURKELA Tax Bar Association. Congratulations, sir. Next, I call upon Raghavendra Kumar Sinha. Advocate Raghavendra Kumar Sinha? Not there. I invite Advocate Subhash Chandra Agarwal. Advocate Subhash Chandra Agarwal will be felicitated by Advocate Mukul Gupta, and I request his son, CA Sailesh Agarwal, to please accompany his father, Subhash Chandra Agarwal ji, on stage. And for the felicitation, I have Advocate Mukul Gupta. He will be felicitating Shri Subhash Chandra Agarwal with a shawl and a memento. Ladies and gentlemen, please give a big hand for Advocate Subhash Chandra Agarwal and a proud son standing beside him, CA Sailesh Agarwal. Congratulations. Congratulations, sir. Next, I invite Hari Prasad Joshi, Advocate Hari Prasad Joshi, to please come on dais. Advocate Hari Prasad Joshi, please. I think we don't have him here in the hall. Next, Advocate Kamal Kishore Agarwal. Advocate Kamal Kishore Agarwal, if you're there in the hall, for the felicitation. Next, Advocate Om Prakash Agarwal. May I please call upon his son, Advocate Akash Agarwal, to receive the felicitation on behalf of his father, Om Prakash Agarwal. Akash Agarwal, if you're there. Both of them are not there. Not there. May I please call upon Advocate Sunil Kumar Kesri. Advocate Sunil Kumar Kesri, if you're there in the hall, no. And last but not least, Ratan Kumar. Subhash Chandra Nayak, Advocate Subhash Chandra Nayak, may please come forward. And along with his son, Sumanta Nayak. I invite Advocate Naresh Agarwal ji to please come forward for the felicitation. Naresh Agarwal ji to felicitate Advocate Subhash Chandra Nayak. He is accompanied by his son, Advocate Shumanta Nayak. And I'm very happy because Shumanta is my student also. Congratulations, sir. We will now take a little time off for preparation for the next session. Thank you. Are we all ready for the second technical session? I think some of them have gone out. We are ready for the second technical session on direct tax. I invite all delegates to come inside, please. We are ready with the second technical session. We were running behind schedule, so we will start immediately. We shall not take a break. Ladies and gentlemen, delegates, please take your seats. We are ready for the second technical session. I welcome back all delegates of the second technical session on direct tax, please. Sir, shall I start the break? Start करें? आप break ले लीजिए, पानी से All delegates are requested to please come into the hall. We'll be starting with the second technical session. Delegates, you're requested to please come into the hall. May I request all organizers to conduct the delegates inside the hall, please? We are beginning with the second technical session on direct tax. Subject, reopening of assessment, WRT, unexplained money, expenditure and assets, critical analysis of search and seizure in the new era, recent jurisprudence in direct and indirect taxation. And for this session, may I please welcome on the dais, Session Chairman, Advocate Uttam Kumar Behra, President AOTAA, to be escorted by Advocate Shumanta Nayak. Please welcome Advocate Uttam Kumar Behra. Thank you, sir. I also welcome Session Speaker, Advocate Paras Kocher, to be escorted by Advocate Naresh. Welcome, sir. We will now present bouquets to our session chairman and session speaker. I request Advocate Pabitra Mohan Pardhan to present a bouquet to Advocate Uttam Kumar Behra. Advocate Naresh is requested to please present a bouquet to Advocate Uttam Kumar Behra. Pabitra Mohan Pradhan, sir, to present bouquet to Advocate Uttam Kumar Behra. Once again, I request all delegates waiting outside. We are beginning with the second technical session. Our speakers are here on the dais. Please welcome our session chairman, Advocate Uttam Kumar Behra. I request Advocate Naresh to present a bouquet to Advocate Paras Kocher. Welcome, sir. I now request Advocate Uttam Kumar Behra, President AOTAA, to address the session.
Ladies and gentlemen, esteemed participants and distinguished guests. In fact, till now, I was thinking in terms that to be inside, on this side of the dais, on the dais was a privilege. But what I find at this moment while delivering to you, that it is a profound privilege to sit in the other side of the dais amidst the few best of the legal brains present here and wonderful speakers that we have with us. So I welcome on this occasion to our learned speaker. No. I know your name, sir. The subject that I was going to tell you, practical aspects of search and seizure. Only he will limit his speech to practical search and seizure, and that, as our learned guest has explained, will be also beneficial to the practitioners who are indulged in GST practice also. So now, before I jump into any other things, today I found that the speech of our Honorable Justice, Chief Justice, Mr. Talapatra was very insightful, because he told three things which I noted down. The first is that they are also aware about the hardship faced by the advocates and dealers throughout the country. They are also equally sensitive about their difficulties. Second thing they said, that it is the system that has to be changed. Because in reassessment procedure he said that it is 80% cases which are found ultimately to be without any foundation. So when we heard this from the horse's mouth, we also must take cognizance of certain things, that the officers who are adjudicating the matters, they are certainly under certain pressure and intimidation also. Now I think that our learned speaker will unveil the spectrum of taxation relating to search and seizure under the Income Tax Act, and which will also be beneficial to us as a DST practitioner. I welcome. Thank you. Thank you.
Thank you, sir. May I introduce our session speaker, Advocate Paras Kocher. Mr. Paras Kocher, advocate, author, columnist and tax consultant practicing at Kolkata, is addressing in the seminars and webinars on direct taxes across the country. He has so far visited 31 cities for delivering his lectures. His workshop, designed on survey, search and seizure, is its kind of only one in India. Corporate and business houses regularly invite Mr. Kocher for this workshop. He also speaks on motivational, spiritual and social topics. Mr. Kocher has written a book on practical aspects on survey, search and seizure in question-answer format. He is authoring another book on Plan Your Future through will, succession, trust, etc., which will be released very soon. His articles on income tax and articles and poems on spiritual and motivational topics are regularly published in various newspapers and magazines. He also runs a channel in YouTube called Swastik Knowledge Care for sharing his views on different topics. Mr. Kocher also appears live on TV channel to discuss various topics of Income Tax Act. His autobiography was also telecast on TV channels. Mr. Kocher handles search and seizure matters in Kolkata as well as also in other cities. He also deals appeals cases and is retainer of corporate houses. He has also been erstwhile president of Direct Tax Professional Association, Lions Club of Toliganj, Avantika, and vice president of Tax Advocates Association of Bengal and BBD Bagh Professional Association, and treasurer of Jito East Sun, and also member of various other associations. Ladies and gentlemen, please put your hands together for session speaker, Advocate Paras Kocher.
Good afternoon, friends. The weather is hot, but the subject is more hot. Friends, जब मुझे गुलदस्ता भेंट किया गया था तो मैं एक बात कहने वाला था, लेकिन माइक नहीं था, तो उस बात को अब बोल रहा हूँ कि एक ही गुलाब काफ़ी था मेरे स्वागत के लिए, गुलदस्ता भेंट कर आपने मेरे दिल को खुशियों से भर दिया। It's a matter of great pleasure for me to be invited by ROURKELA chapter of the Federation. I am also an ordinary member of this federation. Sorry. I am thankful to the conference chairman, Advocate Subhash Chandra Agarwal, and RTBA President, Advocate R.K. Mishra, for inviting me for this session. I am also thankful to Advocate Vivek Agarwal, who was instrumental in this invitation. And I am also thankful to Madam, I don't know the name, for introducing me in this such a excellent manner. Friends, as you all are aware, that income tax is a dull subject. Any law is a dull subject. And I am sure that I will make this subject very interesting. And till the end of my deliberation, no one will leave this hall. I will make this topic so interesting. It's my challenge, friends. Friends, Albert Einstein has said that the hardest thing in the world is to know the income tax. Hardest thing in the world is to know the income tax. And today, I am going to deliver the hardest part of this hardest thing, that is search and seizure. Friends, today's topic, practical aspect of search and seizure in old and new era. I treat changes made after 2013 as new era and post 2013 such provisions as old era. I was given the topic of critical aspects of search and seizure, but I don't criticize anyone. So I requested to change it to practical aspects. I'm not a critic, friends. The Income Tax Act 1961 is containing section 132. Since it was enacted, certain amendments were made from time to time, but no drastic amendment was made in the section 132 till 2013. Only some procedural amendments were made. And the post-search assessment changes are also interlinked with the search provisions, because whenever a search takes place, how we should tackle, how should we face that search, it mainly or it also depends on the post-search assessment. Previously it was 148, then again it was changed to 158 BD, then it was changed to section 150A and C, and now again section 148. So what are the provisions of the post-search assessment? It is also important about the facing the search provisions under section 132. Apart from these changes in section 132 and post-search assessment, there are other amendments in Income Tax Act such as 115 BB or section 271 AD. These sections also affect the search provisions at a great length. To know the impact of search and seizure in new era, it is important to know the practical step of search and seizure. Unless we know the practical aspects, we cannot understand the changes in new era. Friends, there are a lot of misunderstanding, misconception and lack of knowledge among the practitioners as well as the SSC. And because of this much misunderstandings, whenever the search takes place, we fail to face them properly, and the SSC who are also not aware of the provisions of search and seizure, they make huge loss of tax. Therefore, as tax consultants, we should keep our SSCs, keep our clients always updated. And friends, we all know that whenever such takes place, the SSC gets afraid. Even the tax consultants also get afraid. It's very common. But do you know that the income tax officers who conduct a search, they also get afraid. very few of us should be knowing, because हम लोग तो ही जानते हैं कि जब ऑफिसर आते हैं तो वो राजा होते हैं, उनको क्या चीज का डर है? No friends, they are equally afraid when they conduct the search. How I tell you? Few years back, long back, a officer, it was his first duty, he was deputed to conduct search in the residential premises of the MD of Tata Tea. ये 30 साल 35 साल पुरानी बात है, rather 40 साल पुरानी. Since it was his first action, the officer was afraid because Tata Tea MD, a big shot, when he entered into the bungalow of Tata Tea MD, his wife was there, he refused to allow them. Anyhow, he could convince, then she told, okay, I am going for marketing, you do whatever you want to do here. Excepting the servant, no one was in the bungalow. So how they could leave how could they allow the wife of the MD to go out? Then the officer rang to the MD and MD told her wife, then she cooperated. Anyhow, the officer finished his search and left the premises within 4-5 hours. Because he was afraid कि अगर कोई गलती हो गई और complain हो गई तो उसका क्या होगा? These type of fears the officers always have in the mind जब वो बड़ी search करते हैं कोई भी. Once in Calcutta, a SSC was living in a nearby a red light area. When the search was conducted, those ladies came there. It was very difficult for him to conduct the search. In that environment, after the officer is also a human being among us, very recently, a lady officer told me that she went to conduct search in Calcutta in Howrah area. The ladies of that place where the search was conducted were using filthy languages, shouting on them. The lady was afraid, the lady officer was afraid. When she came back, she told her seniors not to send her on such duty. Whenever the search team enters into the premises, particularly the residence premises, there may be dog, it is a bungalow, there may be dogs. Once really a officer anyhow got escape of a dog bite. So these are various problems which these officers also face, and they are also panicked, also under stress when they conduct the search. So this is one part of the officers which you may not be aware, will not be aware. Because entry in the premises is very, very difficult. You might have heard recently in UP there was a search action, and the search team went to the spot in a marriage procession. और वो दिल वाले दुल्हनिया ले जाएंगे गाना गाते हुए गए थे, आप लोगों ने पढ़ा होगा अखबारों में. So entry in the premises is very difficult for the search team. So friends, search seizure action in the premises of any person is very, very dangerous. It is more dangerous than यमराज एक्शन. बिकॉज जब यमराज का एक्शन होता है तो आदमी को हमेशा के लिए शांति मिल जाती है, लेकिन सर्च सीजर जब होता है तो हमेशा शांति नहीं मिलती है, और जब तक वो जिंदा रहता है उसे परेशानियां होती है. एंड सर्च सीजर कैन बी रिपीटेड ट्वाइस थ्राइस इन द लाइफ. यमराज का एक्शन तो एक ही एक्शन होता है, लास्ट एक्शन होता है. सो सर्च सीजर आर मोर डेंजरस देन यमराज एक्शन. फ्रेंड्स, नॉर्मली आई टेक more than 3 hours to complete my deliberation, but I have been allotted only one and a half hour. So I will try to convert my 5-day test match into 3-day test match, and still I hope that it will be interesting, and I will try to bet like Virat Kohli only. Friends, you all are aware that search and seizure is very unlucky. जिसके भी सर्च हो जाती है, it means he is an unlucky chap. Why it is unlucky? There is one more reason. Because search and seizure action is contained, search and seizure section is contained in chapter 13 of the Income Tax Act. And 13 is an unlucky figure. And section 132 of the search and seizure, it also contains the figure 13. And the rules 112 of search and seizure, 12 plus 1 is equal to 13. So always there is 13, so really search and seizure is an unlucky provision. Friends, before I start my deliberation, I would raise a very, very simple question to the learned gathering. What is the difference between search and seizure and income tax rate? Any one of you friend? अगर माइक को तो थोड़ा सा दे दो ऑडियंस में. What is the difference in income tax rate and search and seizure? Any one of you? Please. Yes, very correct. Very good reply. Search and seizure is a legal term used in Income Tax Act, and income tax rate जो है ये बोलचाल की भाषा में कॉमनली टर्म है. अरे आगे बढ़ाओ. Search and seizure means getting hold of such evidence in the form of books of accounts, documents showing undisclosed income or related assets, or seizure of such related undisclosed assets as per section 132 in brief. And there the officer must have reason to believe, only then he can conduct search. Unless he has certain information under his possession and he has reason to believe, only on gossiping, only on suspicion, there cannot be any search and seizure. Recently an explanation has been inserted. It has been amended that reason to believe shall not be disclosed to any person, authority or ITT. It can only be disclosed to High Court or Supreme Court. This is not a welcome amendment. It means that government doesn't want to expose the weakness of the officers. क्योंकि रीजन टू बिलीव लिखने में जैसे 148 है वैसे इसमें भी ऑफिसर्स गलती कर देते हैं और उसका बेनिफिट मिल जाता था, इसलिए उन्होंने झमेला ही खत्म कर दिया. बैक और बैक पीछे. अरे यार हाँ. Who can be searched? Relatives and business associates. Whenever there is a search in a group, along with the group, दूसरे लोगों के पे सर्च हो जाती है. Relatives and business associates, accountants, executives and other staff, directors, tax professionals and auditors, neighbors, consequential searches and due to mistake. Friends, normally if anyone is director in any company and if there is a search in that company, डायरेक्टर के लिए यहाँ सर्च होनी ही होनी है. 99% कोई भी डायरेक्टर हो तो उसके यहाँ सर्च हो जाती है. सपोज योर शॉप इज इन द मार्केट और योर ऑफिस इज इन ए मल्टी स्टोरी बिल्डिंग, और उस बिल्डिंग में या उस मार्केट में किसी के सर्च हो जाती है, या आपके क्लाइंट की ऑफिस वहां पर है, दुकान वहां पर है, एंड द क्लाइंट रिंग्स यू, आस्क यू कि मेरे बगल वाली दुकान में सर्च है, बगल वाली ऑफिस में सर्च है. इस टाइप के फोन्स रेगुलर आते हैं हम लोग के पास में. व्हाट शुड बी अवर रिप्लाई? वेदर ही शुड क्लोज हिज शॉप एंड ऑफिस एंड गो होम, और ही शुड कंटिन्यू हिज बिजनेस? व्हाट शुड बी अवर रिप्लाई फ्रेंड्स? और उसके हो गई तो हो गई तब तो आपको गाली देगा कि आपकी कहने से दुकान खुली रखी. फ्रेंड्स, एक्चुअली वी शुड नॉट एडवाइज देम टू क्लोज द शॉप. बिजनेस एक्टिविटी में जो भी थोड़ी उल्टी पुल्टी हो तो उसको रेस्ट्रिक्ट कर दे, वही केयरफुल होना चाहिए. दुकान नहीं बंद करनी चाहिए. रादर इट क्रिएट सस्पिशन. फ्यू इयर्स बैक एक मल्टी स्टोरी बिल्डिंग में सर्च हुई थी एक क्लाइंट के यहाँ. सर्च कंटिन्यू फॉर 3 days. Second day they found that a office in that same premises was closed since last day. They doubted कि कहीं इसके बैक ऑफिस तो नहीं है, और उसके मालिक को बुला के उसके भी सर्च कर दी. वो बंद क्यों थी कि उसका जो मालिक था उसका एक्सीडेंट हो गया था, तो मालिक ने अपने लड़के को भेजा एंड सर्च वाज स्टार्टेड. और उसमें 5 करोड़ का डिस्पोजल करना पड़ गया. 5 करोड़ का डिस्पोजल बिना मतलब चपेट में आ गया, नेबर होते हुए भी. मिस्टेक. एक चीज ध्यान में रखिए फ्रेंड्स, समटाइम्स हम कहते हैं कि हमारे जो मीडियम क्लाइंट होते हैं, या उनको हम लोग भी कह देते हैं यार तुम्हारे क्या होना है, तुम्हारे पास क्या है. या जो मीडियम क्लाइंट होते हैं वो बोल देते हैं कि हमारे क्या होना है, सर तो बड़े बड़े लोगों की होती है. आई एग्री कि सर्च नॉर्मली वेल्दी स्टेटस वालों के लिए होती है, बट there are certain circumstances because of that सर्च किसी के भी हो सकती है. जैसे कि उसकी कोई पार्टी जोड़ने की वैल्यू हो पर उसके साथ ट्रांजैक्शन होने के कारण उसकी हो सकती है. डायरेक्टर जोड़ने की वैल्यू हो, नेम से के लिए भी डायरेक्टर बन जाता है, उसके सर्च हो सकती है. एंड मिस्टेक के कारण सर्च हो सकती है. आई हैव हैंडल्ड 4-5 सच केसेज इन माई कैरियर जहां मिस्टेक के कारण हो गई. जाना था मान लीजिए सुभाष गुप्ता, द डायरेक्टर ऑफ वन होयारी मैन्युफैक्चरिंग, और चले गए एक दूसरे सुभाष गुप्ता के. सुभाष गुप्ता सेम है, एड्रेस चेंज था और उसके यहाँ चले गए. कोठारी होयारी का मालिक कमल कोठारी, उसके यहाँ नहीं जाके दूसरे कमल कोठारी के चले गए. तो इस तरह की गलतियां होती रहती है, तो मिस्टेक से भी सर्च हो सकती है. सो एवरीवन शुड बी अलर्ट एवरी टाइम. कोई मिस्टेक पता नहीं किसके हो जाए, किसके लिए हो जाए. डायरेक्टर्स, accountants, executive, tax professionals. Yes, tax professionals. नहीं, पंचनामा तो सर्च हुई तब बनी ना. पंचनामा नाम से मतलब ही नहीं है. देखिए, सर्च जब स्टार्ट होती है देन देयर शुड बी रीजन टू बिलीव, बट वंस सर्च स्टार्ट, कोई भी दूसरे एड्रेस पर ऑन सस्पिशन दे कैन गो. तो जो अदर प्लेस था उसमें वो ऑन सस्पिशन उन्होंने उसको ब्रेक ओपन किया, अंडर दिस सस्पिशन दैट द सीक्रेट डॉक्यूमेंट्स ऑफ दिस ऑफिस कैन बी देयर. नहीं, वन सर्च स्टार्ट्स कोई एस्पेक्ट नहीं रहता है. द एंटायर प्रेमाइसेस एंटायर इज ओपन टू देम. और टैक्स प्रोफेशनल्स एंड ऑडिटर्स, बहुत बार ऐसा होता है कि ग्रुप का जो ऑडिटर होता है उसको कवर कर लिया जाता है. इट्स वेरी कॉमन आल्सो. ऑडिटर्स नहीं, वंस दे कम, देखिए सर्च जब होती है तो पर्टिकुलर कुछ नहीं होता है. फिर उस ऑडिटर की जो भी है उस ग्रुप का तो देखेंगे ही, पर सारी चीज चली जाती है, वो फुल सर्च होती है उसके. ऑडिटर को हमेशा कोई भी प्रोमाइजिंग ग्रुप अगर आपका है जहां यू आर एक्सपेक्टिंग कि ग्रुप बहुत बढ़ गया, कभी भी इसके सर्च हो सकती है, तो एज एन ऑडिटर you also be always be careful, particularly when other type of transactions are going between you and the group. हाँ जी, सुनाई नहीं दिया हमको. माइक लीजिए ना, सुनाई. हाँ बोलिए.
डिपार्टमेंट का डिसीजन है ओडिशा हाई कोर्ट का कि टैक्स प्रोफेशनल के यहाँ लिमिटेड टू दैट पर्टिकुलर.
नहीं, मैं बताऊं आपको. ऐसे तो ऑलरेडी डिपार्टमेंट का सर्कुलर, इट्स ए वेरी ओल्ड सर्कुलर दैट द टैक्स प्रोफेशनल्स ऑफ द क्रेडेंशियल्स, टैक्स प्रोफेशनल्स ऑफ हाई क्रेडेंशियल शुड नॉट बी सर्च अनलेस कोई कंक्रीट एविडेंसेज हो. तो ये सर्कुलर इज देयर. बट टैक्स प्रोफेशनल्स को अगर ये किसी ग्रुप के साथ में इन्वॉल्व करते हैं तो नॉर्मली दे हैव द इंफॉर्मेशन कि ये जो एकोमोडेशन एंट्री वगैरह है उस ऑडिटर के थ्रू हो रही है, उस सीए के थ्रू हो रही है, देन दे कवर हिम विद दिस रीजन टू बिलीव. और वंस दे कवर, उसके क्लाइंट के डॉक्यूमेंट नहीं ले सकते वो. टैक्स प्रोफेशनल्स के ऑडिटर के जो अदर क्लाइंट्स है उसके डॉक्यूमेंट नहीं ले सकते। एक अर्नेस्ट सिंह का बाटली बॉय का केस है, उसमें उसके आर्टिकल जो है वो सुप्रीम कोर्ट का जजमेंट है, उसके आर्टिकल जो है दे वर वर्किंग इन ए क्लाइंट्स ऑफिस, वहाँ सर्च हो गई और उनका लैपटॉप भी ले गए। तो बाटली बॉय वेंट अप टू सुप्रीम कोर्ट कि भाई इसमें हमारे क्लाइंट्स के और डेटाज भी है, हाउ दे कैन सी दिस लैपटॉप। अल्टीमेटली सुप्रीम कोर्ट ने ऑर्डर दिया कि लैपटॉप बाटली बॉय के प्रेजेंस में खुलेगा और जिस क्लाइंट के सर्च हुई थी उसके अलावा कोई डॉक्यूमेंट ये नहीं लेंगे, बाकी रिलीज कर देंगे। दैट इज देयर, इज द सुप्रीम कोर्ट जजमेंट ऑफ बाटली बॉय। फियर ऑफ कंसिक्वेंशियल सर्चेज, अगर कहीं सर्च चल रही है और वहां कुछ भी डॉक्यूमेंट्स या कोई इंफॉर्मेशन मिलती है रिलेटेड टू अदर ग्रुप, then they can be searched in the other group also, or they can be surveyed in other group also. So that fear is always there. Whenever a such action is going on, there can be a concealed search in other party, other group, other person. Whenever there is a search, the professionals, my fellow professionals ask me that can my client be searched or can I be searched in connection with my client search? It's a very common question. So then, as the tax professionals, as the auditors, as chartered accountants, you must think that whether there is a search or survey. First, so you try to find out whether there is a search or survey. क्योंकि एक्शन स्टार्ट होता है और हम लोग को पता ही नहीं है एक्चुअल सर्च चल रही है कि सर्वे चल रहा है. Then whether they are transaction with the said group not recorded in regular books of accounts. Only then there is a fear of search. अगर कोई गलत ट्रांजेक्शन नहीं है तो कभी भी सर्च कंसिडरेशन नहीं होगी. और whether the said group is in city और आउटसाइड कलकत्ता. अगर कलकत्ते के मान लीजिए आप राउरकेला में है और कलकत्ते में सर्च चल रही है आपसे कनेक्टिंग क्लाइंट के, ये नहीं है कि यहाँ हो नहीं सकती, चांसेस कम हो जाते हैं. Friend, day, time and place of search. Any one of you can tell which day, what time and which place search can take place. There are three things: day, time and place of search. Please बताइए. Day, time and place of search. अरे Mike, after 10:30, after 6, after sunrise. But after sunrise. Anyone friend? इन्होंने कहा आफ्टर सनराइज एनी डे एनी प्लेस. आप लोग में से कोई और ऑल ऑफ यू एग्री विद दिस रिप्लाई? बिकॉज दीज आर वेरी स्मॉल क्वेश्चन बट वी मस्ट बी अवेयर ऑफ ऑल दिस क्वेश्चंस. अदरवाइज होता है क्लाइंट के सर्च होती है, हम लोग बोलते हैं नहीं नहीं वो तो सर्च गलत हुई है और क्लाइंट उनसे भिड़ जाते हैं. ये नहीं होना चाहिए, ये जानकारी बहुत जरूरी है. प्लीज टेल फ्रेंड्स विच डे विच प्लेस व्हाट टाइम द सर्च कैन टेक प्लेस. Business place and what time, which day? Anyone? Friends, आपका नाम? टिबड़ीवाल. टिबड़ीवाल जी was not absolutely right. थोड़ा सी भूल हुई इनसे. Search can take place in any place, whether it is business or residence. Any place, any day, 365 days, irrespective of even national holidays, Sundays, it doesn't count, even if it's a national holiday. But 24 hours, not sunrise. You told me sunrise, no. 24 hours, any time in the day, such can take place. Means any day, any time, any place. Yes, I am coming to that. His question is कि रात को 12 बजे. Absolutely right, Tibrewal ji. If you are sleeping in your house at 12 o'clock in the night with your lovely wife, income tax department cannot disturb you. Cannot disturb you. Then your question is कि आप तो बोल रहे हैं कि any time और आप बोल रहे 12 बजे नहीं आ सकते. The legal provision is that any time, 24 hours. Why the legal provision is there? Because suppose a man is coming from Bombay to Calcutta in the aircraft at 12 o'clock and he is carrying huge cash, huge gold, huge diamonds, what it may be. and the income tax department gets the information that he is carrying undisclosed assets. Department cannot wait for him up to morning, तब तो निकल जाएगा. That is why the provision there. तो डिपार्टमेंट एयरपोर्ट में 12 बजे रात को 1 बजे जाके वारंट इशू करके कैच होल्ड कर लेगी. बट इट डजंट मीन कि किसी के घर में, किसी भी सिटीजन के घर में वो रात को पहुंच के सर्च करे. दे आर नॉट अलाउड. प्रोविजन है फॉर स्पेसिफिक पर्पज. लेकिन वो आपने रामदेव बाबा का किस्सा सुना होगा, दिल्ली में जो रात को रामलीला मैदान में धरना दिए थे, रात को चले भाग गए थे, पुलिस आ गई थी. उसका सुप्रीम कोर्ट का जजमेंट है. एंड सुप्रीम कोर्ट सेज दैट नो एजेंसी कैन डिस्टर्ब द स्लीप ऑफ एनी सिटीजन. इसलिए रात को सर्च नहीं हो सकती है. बट प्रोविजन इज देयर. एंड दी सर्कमस्टांसेस कि जैसे मैंने एयरपोर्ट का एग्जाम्पल दिया, वैसे सर्कमस्टेंस सर्च हो सकती है. नो, ऐसा है जी. अभी तक जो सिस्टम है वो यही है कि सर्च आपकी एक बार स्टार्ट हो गई, इट कैन कंटिन्यू फॉर 2-3-4 days. वो रात को भी वहीं रहते हैं. हाँ, ये अलग अलग जगह अलग सिस्टम है. कलकत्ता में दे डोंट स्टॉप. वो रात भर काम अपना करते रहते हैं. हाँ, आपको नहीं डिस्टर्ब करेंगे. जिसका सर्च हुई है ही विल बी अलाउड टू स्लीप, बट वो अपना काम करते रहते हैं. बट दे आर सर्टेन सिटीज, वहाँ पर वो रात को जॉइंट सील में बंद करके आ जाते हैं, फिर सुबह चालू कर देते हैं. ये हाँ, ऐसे के घर में कोई तो होगा, उसकी वाइफ होगी, उसका भाई होगा, उसका बेटा होगा, देन सर्च विल कंटिन्यू. और नहीं कोई होगा तो किसी रिलेटिव को बुला लेंगे, विटनेस को बुला लेंगे, सर्च कैन कंटिन्यू. देखिए नियम यही है. बट नॉर्मली आजकल बहुत सारे लोग विटनेस को बुला के साइन करके छोड़ देते हैं, वापस लास्ट में बुला लेते हैं. बट लॉ यही है कि जब तक सर्च चलेगी विटनेस हैज टू बी देयर. एक गारमेंट शॉप में कलकत्ते में रात को 10 बजे सर्च स्टार्ट हुई. एक डायमंड मर्चेंट के यहाँ शनिवार को सर्च स्टार्ट हुई. बेंगलोर में एक हीरोइन के यहाँ संडे को 4 बजे सर्च उन्होंने की, बिकॉज दे हैड सर्टेन स्पेसिफिक इंफॉर्मेशन. और उनको 4 करोड़ रुपया कैश मिला, जो उनके सामने ही लाया गया था, उसी समय लाया गया था. देयर आर वेरियस एग्जांपल्स ऑफ सर्च अदर देन वर्किंग डे. अरे भैया इधर देखो थोड़ा. अरे इधर देखो यार, इधर ध्यान दो. आगे चेंज. हाँ बस. प्री सर्च वर्किंग. व्हेन दे कम फॉर द सर्च they make some working department. मैं शॉर्ट में बता देता हूँ. They prepare their case, they collect the information, they make the satisfaction note to be searched. It is important. The place which they are going to be searched, they make recce of that place. What is recce? Friends, everyone should ask his client to be very careful as regards the recce of the income tax people is concerned. Income tax people can enter into the residence as telephone person, as electric person, as municipality person, and normally we don't see any identity card. We allow him. वो आ जाएंगे और सारा घर का अवलोकन करके चले जाएंगे. He can come to your office as the prospective client. He can come to your client's office as the buyer or the seller. रियल एस्टेट बिजनेस में इट्स वेरी कॉमन, बिकॉज जब बिल्डिंग बनती है दे गो देयर, दे आस्क फॉर द फ्लैट, दे आस्क द प्राइस, और नॉर्मली यू नो कुछ प्लस माइनस होता है, एंड वो सारा बता देते हैं. हाँ 80% प्लस 20%, और ऑन द बेसिस ऑफ दैट दे मेक द एंटायर कैलकुलेशन ऑफ द एंटायर बिल्डिंग कि एक फ्लैट में इतना है तो टोटल फ्लैट में इतना, या पर स्क्वायर फुट इतना है तो, एंड दे कैन मेक ए वेरी गुड नोट कि भाई इसमें इतना इवेजन हुआ है. सो रियल एस्टेट में जितने भी क्लाइंट्स है, यू शुड आस्क देम not to be very talkative with any person. और तुरंत जब तक कि नहीं मालूम है कि पर्सन जेन्युइन है कि नहीं, तुरंत ये सब बात नहीं कर लेनी चाहिए. रियल एस्टेट की जितनी भी सर्च होती है मैक्सिमम में रेकी इसी तरह से हो जाती है. यस. Then warrant has to be issued. Then they ask all the officers to assemble in the one place in income tax building then warrant is served on the premises of the SSC and next. Pre-search precaution. वो तो कि ऑफिसर्स क्या करते हैं, what precaution the SSC should take, what we should advise our client to take precaution so that the impact of the search can be reduced. There should be no incoming document. जितने एडिशन होते हैं मैक्सिमम ऑन द बेसिस ऑफ इनकमिंग डॉक्यूमेंट, 5-5 साल पुराने 8-8 साल पुराने कागज मिल जाते हैं और क्लाइंट को पता ही नहीं है, क्लाइंट इज नॉट अवेयर, और उन पेपर्स के बेसिस के ऊपर क्रोर्स के एडिशंस हो जाते हैं. क्लाइंट इज नॉट अवेयर ऑफ दो डॉक्यूमेंट्स. लैपटॉप में, कंप्यूटर में 5 साल पुराने 8 साल पुराने डॉक्यूमेंट्स के बेसिस पर एडिशंस हो जाते हैं. नॉट ओनली वी शुड ऑलवेज guide our clients that you should be very careful as regard the income documents are concerned. और उसमें इतनी बड़ी टैक्स लायबिलिटी आ जाती है कि क्लाइंट का बेड़ा पार हो जाता है. इतनी बड़ी टैक्स लायबिलिटी आ जाती है. अब तो आप यू आर अवेयर 60% टैक्स एंड पेनल्टीज, कितना बड़ा अमाउंट हो जाता है. रफ एंड वेस्ट पेपर, इट्स अगेन ए कॉमन हैबिट कि कोई भी कागज, सपोज यू मस्ट बी नो व्हाट इज रुक्का, मान लीजिए लोन का रुक्का है, प्रोमाइजी नोट लोन का, वो काम हो गया, उसको आपने क्रॉस किया, अरे अभी तो पीछे जगह है एंड यू यूज इट. अब उसमें मान लीजिए आपके आउट ऑफ द बुक्स लोन दिया हुआ है, लिखा हुआ है उसमें, आपने उसको क्रॉस करके उसको यूज करना शुरू कर दिया पीछे में. बट इफ दैट डॉक्यूमेंट इज फाउंड कॉट, तो वो आपके क्रॉस करने से वो ट्रांजेक्शन खत्म नहीं हो गया. इसलिए एनी सच ट्रांजेक्शन यू जस्ट पुट इनटू द कटिंग मशीन. नेवर यूज द यूज डॉक्यूमेंट. यूज रफ डॉक्यूमेंट को रफ मत बनाइए, उसको आप फाड़ के फेंक दीजिए. इन सच वी फाइंड सो मेनी डॉक्यूमेंट्स और अननेसेसरी एडिशंस हो जाते हैं जिनका कोई यूज ही नहीं था, ओनली बिकॉज ऑफ दिस बैड हैबिट. व्हाट्सएप, SMS एंड ईमेल्स. व्हाट्सएप आज के दिन सब बहुत यूज करते हैं, मैं भी करता हूं और बहुत यूजफुल भी है, लेकिन एज ए सर्च इज कंसर्न, व्हाट्सएप इज द बिगेस्ट एनिमी. व्हाट्सएप में हम लोग जो मैसेज रहते हैं, पहली बात उसे डिलीट कर देना चाहिए, और इवन आफ्टर डिलीट भी up to a certain time they can retrieve it. एंड व्हाट्सएप में जितने भी इनकमिंग मैसेज है, इनकमिंग मैसेजेज, वो सब इनको मिल जाते हैं. आपके अनअकाउंटेड ट्रांजेक्शन्स जो हम लोग लिख के भेज देते हैं, हिसाब बना के वापस आ जाते हैं, वो सब मिल जाते हैं. व्हाट्सएप का यूज बहुत ही डेंजरस है. बड़े बड़े एडिशन जो हैं खाली व्हाट्सएप के इन मैसेजेस के ऊपर हो जाते हैं. तो व्हाट्सएप में कोई भी इस तरह का इंफॉर्मेशन फीड करके मत रखिए, फ़ोन में मत रखिए, मोबाइल में, और उसको मोबाइल के द्वारा, व्हाट्सएप के द्वारा मत भेजिए क्लाइंट को, या क्लाइंट को बोले अपने कस्टमर को नहीं भेजे, अपनी पार्टी को नहीं भेजे. इट्स वेरी 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 रिस्की. सेम इज द ईमेल्स, क्योंकि जब भी सर्च होती है दे टेक द मोबाइल विद देम, दे आस्क यू द पासवर्ड, और उसके बाद में ईमेल्स वगैरह सब चेक करते हैं, और उसमें उनको काफ़ी इंफॉर्मेशन मिल जाती है. ये उनका मेन ट्रेजर है डिपार्टमेंट का. वन थिंग मोर, सपोज समबडी इज नॉट स्टोरिंग एनी सच मैसेज इन मोबाइल, वो सोचता हमको क्या चिंता है. बट वन प्रॉब्लम कैन बी देयर. ए मैरिड मैन, he has extramarital relation, he is having chat with his girlfriend, और उसमें ऑफिसर ने देख लिया, पढ़ लिया, क्योंकि ऑफिसर सारा मोबाइल बहुत माइन्यूटली चेक करते हैं. अब ऑफिसर के हाथ में खजाना मिल गया. he tells to the client and to the person concerned कि भैया डिस्क्लोजर कर दो, अदरवाइज आई विल गिव इट टू योर वाइफ. बेचारा मरता क्या नहीं करता. एंड ये वो ब्लैकमेल पैसा लेने के नहीं कर रहा है ना, इट इज ब्लैकमेल, लेकिन वो तो डिपार्टमेंट का टैक्स दिलवा रहा है. इट हैज हैपेंड सेवरल टाइम्स। तो ये सारी बातें भी ध्यान में रखने की है, और आप लोग भी कोई ऐसा रख रहे का ध्यान रखिएगा। हार्ड डिस्क एंड पेन ड्राइव्स, एज आई टोल्ड यू कि 18-10 साल पुराने रिकॉर्ड्स मिल जाते हैं हार्ड डिस्क में, पेन ड्राइव में मिल जाते हैं। पेन ड्राइव क्या है? एसएससी सारा निचोड़ पेन ड्राइव में ले लेता है, एंड ही इज हैप्पी कि एक पेन ड्राइव है वो कहीं भी रख लेता है, कोई दिक्कत ही नहीं, उसको सर्च आएगी तो क्या है। बहुत से लोगों की थोड़ी सेखी मारने की हैबिट होती है, दे कम टू मी एंड टेल सर आई डोंट हैव एनी प्रॉब्लम, एवरीथिंग इज माई पेन ड्राइव। एंड पेन ड्राइव, यू नो, द बिजनेसमैन लव्स पेन ड्राइव एज मच एज ही लव्स हिज वाइफ, क्योंकि इसलिए पेन ड्राइव को यहीं रखता है वो। एंड सर्च के दिन या ऑफिस में वो जब पॉकेट देखते हैं तो पेन ड्राइव मिल जाती है, और सर्च के दिन नॉर्मली पेन ड्राइव उनको बेडरूम में कपाड़ में या पलंग के पास मिल जाती है। देन व्हाट इज द यूज ऑफ कीपिंग दिस सीक्रेट डेटाज इन द पेन ड्राइव? जब पेन ड्राइव itself भी आपकी चली गई, संजीवनी बूटी नहीं तो पूरा पहाड़ी लेके चले गए हनुमान जी, वो तो और ज्यादा डेंजरस हो जाती है जब पेन ड्राइव डिपार्टमेंट ले जाता है तो। सो ऑलवेज कीप पेन ड्राइव इन वेरी वेरी सीक्रेट प्लेस। ओनली कीपिंग डेटाज इन द पेन ड्राइव doesn't relax the SSC, should not relax the SSC. Same is the case of hard disk. One advice I will give, very frank advice, I should not give in this open platform, but I think it will benefit for everyone. At least advise your client to change the hard disk every year and keep the hard disk in a separate place. आपका 10 साल का चक्कर तो नहीं आएगा। अगर वो हार्ड डिस्क में कुछ है भी तो आपका 1 साल तक का ही ट्रांजेक्शन है, ओनली 1 ईयर दैट ईयर, नॉट द एंटायर 10 ईयर्स। एकदम अपने क्लाइंट जो भी प्रोस्पेक्टिव क्लाइंट है जिनके सर्च के चांसेस है, एडवाइज देम कि हार्ड डिस्क एवरी ईयर, भले 2-4-5 हज़ार का खर्चा ही, इससे बेसी कोई बात नहीं है। एडवाइज देम टू चेंज द हार्ड डिस्क एवरी ईयर। Updated books of accounts, they should keep the accounts updated. Cash in hand, physical cash in hand should tally always with the cash in hand in the books of accounts. Updated stock register, investments and valuables, all should be there. No other person's document. Sometimes what happens, suppose a client comes to your office और वो अपना कोई बैग भूल गया। आप बोले ठीक है, if he has forgotten, I will send him after 2 days or he will collect it after 2-3-4 days. और बैग में उसके सारे कच्चे चिट्ठे हैं या कुछ इस टाइप के ट्रांजेक्शन के कागज है, नेक्स्ट डे सर्च आ जाती है, वो कागज वो भी गया आपका, एंड यू आर अनेबल टू एक्सप्लेन। उसमें मान लीजिए उसका नाम ही नहीं लिखा है, सब लिखे हुए हैं, देन दैट विल बी प्रिज्यूम्ड टू बी योर्स एंड यू विल हैव टू पे टैक्स ऑन दैट। इसलिए किसी का भी कागज छूट जाता है, किसी के खाता छूट जाता है, उसको तुरंत भेज दीजिए, अदरवाइज अदर पर्सन के डॉक्यूमेंट से बेकार का हम लोग फंस जाते हैं। बुक्स ऑफ अकाउंट शुड आपका डेली का डेली अपडेटेड रखिए, चेष्टा हुई की। देखिए वो बहुत डेंजरस है जी। एक्चुअली होता क्या है कि हम लोग जो एडजस्टमेंट करते हैं उसको डिलीट ही नहीं करते हैं। Whatever we make adjustments, 2-3 ट्रायल रहते हैं, 2-3 बैलेंस शीट उसमें रहती है। दिस इज द वर्स्ट हैबिट। क्लाइंट को भी बोलिए डिलीट कर दे, और हम लोगों को भी अपने लैपटॉप से तुरंत उसको डिलीट कर देना चाहिए, कभी भी नहीं रखना चाहिए। देखिए वो रिटाइव कर लें तो फिर भी मिल जाएगी, लेकिन अप्रेंटली सब चीज तो रिटाइव नहीं करते हैं, डाउट होने पर करते हैं। अप्रेंटली तो आपके सामने आ जाएगी ना। आपकी ऑडिटेड बैलेंस शीट कुछ बोल रही है, दूसरी बैलेंस शीट कुछ बोल रही है, आप उसको रिकॉन्साइल ही नहीं करा पाएंगे, तो रिकॉन्साइल कर सकते हैं तब तो ठीक है, दे आर सर्टेन प्रॉपर एडजस्टमेंट, देन देयर इज नो प्रॉब्लम। अदरवाइज आप नेवर कीप इट इन दैट। और सच में यही सब तो एडिशंस हो जाते हैं। नेक्स्ट हो भैया, अरे यार, स्टेप्स आफ्टर कमेंसमेंट ऑफ सर्च ऑपरेशंस, असेंबली ऑफ फैमिली मेंबर्स। स्टेप्स यूं ही वो आते हैं, दे आस्क ऑल द फैमिली मेंबर्स एंड स्टाफ टू एट वन प्लेस, सबको इकट्ठा कर लेते हैं। Then they take the preliminary statement. A very small preliminary statement is recorded. and they start counting and valuation of cash, jewelry and inventories, poverty order on banks and lockers under section 132(3). Poverty order means they ask the bank not to operate the bank account. पहले तो it was very common, आप अगर 200 bank account, they used to issue poverty order. Disclosure of undisclosed income, their only intention is to ask for the disclosure of undisclosed income. Recording of statement final statement is recorded after the search is over, complete. जब सारा काम हो जाता है उसके final seizure of valuables, books of accounts etc. They seize the valuables and books of accounts and preparation of Panchanama. At the end the Panchanama is prepared, जिसमें सारी डिटेल्स रहती है कि उन्होंने क्या किया क्या नहीं किया. हाँ भैया, नेक्स्ट. Yes. Steps after commencement of is continuing. Inquiry and investigation, issue of summons to third parties, Majanama for operation of seized electronic data, withdrawal of provisional order, recording of statements, appraisal report, transfer of these all work they do during course of search and seizure operation. Next. What can be seized? Cash can be seized, fixed deposit rate, NSC, securities, bond, etc. Jewelry, bullion, diamonds, books of account, documents, loose papers, computers, laptop, hard disk, pen drives, and mobile phones can also be seized. Next. Jewelry लिखा ना मैंने. I'm coming to jewelry point. बहुत लंबा है. What cannot be seized? Passport cannot be seized. Stock in trade cannot be seized. And place stock in trade. Next. Powers and duties of officer. To show warrant and identity card, to ask the person to assemble at one place, to take body search, to call 2 witnesses of the locality. Of the same locality, they will call for 2 witnesses. If वहाँ आपको 2 स्मार्ट विटनेस को बुलाना चाहिए, वो आपको ही बोलेंगे बुलाइए, सो आप देखिए कौन स्मार्ट आदमी है, उनको बुलाइए, तो they can be helpful for you in the search proceedings. To show sympathy to ladies, aged persons and children, to break open suspicion place and things. कोई भी सस्पिशन होने पर कोई भी दीवार वगैरह कुछ भी वो तोड़ सकते हैं. इसमें हमारे वीडियो है, इसके बाद हाँ वीडियो चलाइए, वीडियो है. आवाज 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 भी है, आवाज
कुरेद के किवाड़े खोद के निकाले गड़ा है जो है तिजोरियों में या बंद बोरियों में खुफिया कहीं पे पड़ा है जो बतलाता है काले धंधों का पारा पारा खजाना तेरा ये सारे का सारा 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 फ्रेंड्स. पिक्चर में जो दिखाया गया है इट्स एब्सोल्युटली करेक्ट. मैंने आई हैव शोन यू ए ट्रेलर सो यू कैन जस्ट विजुलाइज हाउ द सर्च कैन टेक प्लेस. कैसे दीवार तोड़ी गई है. इट्स नॉट ऑलवेज बट समटाइम दे डू इट. और कहीं भी जगह में आप छुपा के रखे हो वो खोल लेते हैं. once in a restaurant a mother was very anxious for his small baby. उसके गले में कुछ अटक गया था, समथिंग देयर वाज इन हिज थ्रोट, और वो निकाल नहीं पा रही थी. सब इकट्ठा हो गए और लगा कि थोड़ी देर नहीं निकलेगा तो लड़का मर जाएगा. ए पर्सन केम देयर और उसने 2 मिनट देखा और कुछ किया. एक मिनट के अंदर सिक्का निकल गया. वो 1 रुपये का चांदी का सिक्का अटक गया था. वो भी चीज़ थी. तो बोले आप कौन है? ही टोल्ड मी आई एम इनकम टैक्स ऑफिसर. तो ये इनकम टैक्स वाले कहीं से भी कोई भी चीज़ निकाल सकते हैं. नेक्स्ट.
Yes, they can ask us to inspect the books of accounts. We will have to provide them facilities, and they will call the valuer for the valuation of the seized jewelry. Next. Authority to call any person. They can call police. Not only they can, वो जब सर्च का दिन फिक्स करते हैं तो उसी समय पुलिस से टाइम ले लेते हैं. अगर पुलिस अवेलेबल नहीं है तो सर्च नहीं करेंगे. In every search, police will come with them. They can also call any officer of the central government, ED, CBI, any officer they can call with them, Income Tax Department. Valuer of property and jewelry, they can call the valuer of property, jewelry, shares, etc. with them. Computer experts they can call, digital forensic professionals they can call, archive expert and locksmith carpenters, they can call any of them when they start the search or doing the search when required. It is well within their power. Time hai to, abhi to. They can make provisional attachment and reference to other officers, valuers, etc. they can make. Next. Awareness and knowledge of ladies and housewives. When the search takes place in the residence, friends, ladies are there, housewives are there. Sometimes even the male member is also not available, or sometimes even if he is available, he is stuck in the office. So ladies are to deal the search officers. And in most of the families, ladies do not know anything about the business. In most of the families. But it creates nowadays. As a tax consultant, as a chartered accountant, as an auditor, as an advocate, you must advise your clients about the ladies. Unless you advise, and if any such action takes place, there can be really a problem. Friends, the ladies during course of search, they ask certain unofficial questions to the ladies, and when they find that these questions are not as per the books of accounts, then they record the statement of the housewives. Quantum of household expenses. Whatever personal expenses, household expenses are shown in the regular books of accounts by the client, excepting salaried persons, as regard the businessmen are concerned, there are very few which show the exact household expenses in their regular books of account. ड्राइंग 5 लाख की दिखाएंगे, खर्चा 20 लाख का. I think I am correct. And ladies is aware of that 20 lakh only. क्योंकि वो उसके घर आता है 1.5 लाख रुपए महीना या 2 लाख रुपए महीना, वो उतना स्पेंड करती है. So she knows कि what is the household expenses. When this question is asked to the housewife, she replies with happiness. कि हाँ, हम तो 2 लाख रुपए खर्चा हमारा. But in the books, only 5 lakh is there or 10 lakh is there. So at least ask your clients to make the wife aware about the personal expenses being shown in the books of accounts. Otherwise, पिछला 6 साल का 10 साल का अगर रिकॉर्ड हो गया, 50 लाख से ऊपर का खर्चा है तो 10 साल खुल जाएगा. Huge tax liability will be there. Income shown in the return of income of housewife, she should be aware कि what is the income of directors in the company, remuneration recorded and attendance in board meeting, and partner in partnership firm or LLP, share of profit and remuneration from firm. Common point. Now, ladies are being also made directors or partners in the companies and in the partnership firm. It's also very, very common, friends. And remuneration is also being given as a director, working director, or as a working partner. And big remuneration, 1 lakh rupees per month, 2 lakh rupees per month. But when there is a search and seizure,
in the residence, and several questions are asked to the lady that, are you director in any company? She said no. Because she is not aware, or if even she is aware, she can reply, yes, I am director in this company. Then next question will be, what is the remuneration you are getting? Again, the question reply may be wrong or right. 80% wrong chances, 20% it can be right. Then similar where the office, where the board meeting takes place, how many questions he will reply? Huh? No, this is a statement. This is not question of intimating. This is a statement. A statement of the lady will be recorded, and on the basis of that statement, your assessment will be made. Yes, yes. Statement can be recorded by mail. Otherwise, also in the residence, a lady officer will go. Yes, many. Always in the when there is a search in the residence, out of 4 or 5 officers, 1 officer will always be a lady officer. पर्दा नसीन है कहाँ तो वो तो बोले ना, मुसलमान के यहाँ जाए तो बोल दे कि हमें पर्दा नसीन हो, मुस्लिम से हैं, अपने कहाँ हैं बताइए? वो तो देखने से मालूम पर्दा नसीन है ही कहाँ, बताइए उसके सामने आइए कहाँ पर्दा नसीन है? तो यहाँ सपोज द wife of the client is very smart and she is able to reply all the questions, where the meeting takes place, what is the remuneration, where is the office, what is the business, all questions आपने पढ़ा दिया और वो बहुत स्मार्ट है, सारा जवाब दे दिए. But the last question which she if asked to her, and that is the question that, well, ma'am, the officer can ask her, ma'am, what work you do in the office? सारा तो दिखा दिया, बता दिया, अब काम के बारे में क्या बताए? If she says I look after purchase, or I look after sales, or I look after accounts, then again several questions will be asked about accounts and purchase. She cannot reply. आप कुछ भी सिखा दो, लेकिन उससे रिलेटेड क्वेश्चन तो नहीं बता सकते. किस पार्टी से काम होता है? There are several questions. Can you tell what should be the reply? हस्बैंड की सेवा करती है, ये पर्सनल है, इट इज नॉट बिजनेस एक्सपेंसेस. बताइए, इफ योर क्लाइंट आस्क यू कि बताइए हम क्या जवाब दें, वाइफ को क्या बताएं अगर ऐसी सिचुएशन है कि क्या काम करती है, तो क्या बताएं? आप उसको एडवाइस तो कर दिए कि 1 लाख रुपये रेमुनेशन दे दो कंपनी से, एंड इज फॉलोइंग योर एडवाइस, लेकिन जब ये क्वेश्चन पूछता है तब आप क्या जवाब देंगे? एनी ऑफ यू फ्रेंड? है, मैं धन की बात नहीं कर रहा, बिजनेस में क्या करती है, ऑफिस में क्या करती है, कंपनी में क्या करती है, फर्म में क्या करती है? क्या चीज? मैनेजमेंट. व्हाट मैनेजमेंट? अब आप दोनों पार्टली राइट है, खाली साइन मारने का पैसा नहीं मिल सकता है, वर्किंग होना चाहिए. आप दोनों राइट है. हाउ बोथ ऑफ यू आर राइट? इसको मिक्स कर लेते हैं. द रिप्लाई शुड बी लाइक दिस. I go to office because my husband normally remains out of office, either out of town or out of office. And you are well aware that in the absence of the owner, staff काम नहीं करता है, gossip करता है, WhatsApp देखता है. I just sit there और मेरे बैठने से ही सब attentive होकर दिन भर काम करते हैं. This can be the reply. इसमें कोई counter question नहीं हो सकता. Next. And a question can be asked to the housewife about the bank locker. So bank locker, if really she is having, she should not tell lie. She should accept, yes, I am having bank locker. And if she doesn't have any bank locker, she can say, I don't have any bank locker. But no false reply should be given. Next. Next. मैं आ रहा हूँ लॉकर में, फिर आ रहा हूँ डिटेल में, आपका क्वेश्चन मिल जाएगा उसमें. ज्वेलरी. Someone was asking about the jewelry. It is again a vital, आपके लिए बहुत important है. Anyone? Yes. Jewelry.
the ladies are fond of jewelry. I am very blunt, as much as the fond of husband. ज्वेलरी लेडीज के लिए बहुत जरूरी है. जितनी सर्च होती है, as soon as the search takes place, and after 3, 4, 5 days, it might be that there may be a disclosure of 50 crore. But the wife of the SSC just ring me and ask, sir, मेरी वो 2 करोड़ की ज्वेलरी ले गए, वो कब छूटेगी? She is not concerned about the 50 crore tax, but she is concerned about a 2 crore jewelry only. And I have seen that in so many cases, even if the jewelry is disclosed, it is seized. It is not because of the department is harassing. Department never seizes a disclosed jewelry. It is only because we are unable to explain the jewelry at the time of search properly. Even if it is a disclosed jewelry, we fail to explain. If we fail to explain, it will be seized. How to keep jewelry? You should take photograph of the jewelry, which has been shown in the wealth tax return last 2014, and put serial number of that valuation report of that wealth tax return below every photograph of the jewelry, so that when at the end of the search, in midnight when the jewelry is valued, it can be tallied with the photographs, with the previous valuation report. So if the jewelry is found in the previous wealth tax return, it cannot be seized. Secondly, suppose that time is diamond set consisted of 5 items. लेकिन at the time of search, एक आइटम कोई भी कारण से घर में नहीं है, पीएन में छूट गया, कहीं छूट गया, it might be. So the weight will not tally. Obviously एक आइटम का weight नहीं tally होगा, और जब तक वैल्यूएशन होती है इतने नर्वस हो जाते हैं, इतने डिप्रेस हो जाते हैं, वो दिमाग में नहीं आता कि 5 आइटम 4 आइटम का क्या फर्क है, ये वेट कम है. लेकिन अगर आपकी एल्बम है, देन यू कैन सी कि अरे ये 5 अच्छा हमारा एक आइटम छूट गया, देन यू कैन कन्विंस कि देखिए ये आइटम छूट गया, ये 4 आइटम मिला के 5 होने से वेट मिल जाएगा. तो कीपिंग द फोटोग्राफ्स of each and every jewelry being disclosed saves the seizure of the jewelry. Apart from this, you always keep file of these items with you, valuation report of the jewelries, bills and other evidences. अगर बाद में कोई परचेज हुई है या कोई मेकिंग हुई है, रीमेक हुई है, keep the bills and also keep the wealth tax returns. Bills are missing? No, if bills are missing, yes, if you are unable to explain, give any concrete evidence, that jewelry will be treated and disclosed and it will be seized. And apart from the bills, you also keep the bank statement. क्योंकि बिल का पेमेंट आपने अगर चेक से किया है, तो you can show the bank statement that this is the check payment and this is reflected in the bank statement. And keep 3 files of such records. Why 3 files? 1 file at the residence, 1 file at the office, and 1 file at your office. आपके क्लाइंट को बोले 3 फाइल बनाएगा, 1 फाइल आपके ऑफिस में रखिए. बिकॉज ऑन द डेट ऑफ सर्च हो सकता है कि अकाउंटेंट हैज नॉट कम, तो ऑफिस की फाइल नहीं मिले, घर की फाइल भी डिप्रेशन में, नर्वसनेस में कहीं छप गई है, आपको नहीं मिल रही है, या मिल भी गई है, तो इफ द 1 फाइल इज विद द कंसल्टेंट, नॉर्मली टैक्स चार्टर्ड अकाउंटेंट एंड एडवोकेट्स आर नॉट अलाउड ऑन द डेट ऑफ सर्च टू एंटर इनटू द प्रीमाइसेस. आजकल दे आर वेरी स्ट्रिक्ट. Then you can go to the premises of your client with that file and tell the officer, sir, wealth tax record are with me. तो ज्वेलरी के लिए दरकार है, तो I want to give it to my client. They will allow you. और अगर आप 2 मिनट के लिए भी क्लाइंट के पास चले गए, उसको लगेगा जैसे भगवान आ गया. Really, he will feel very relaxed when he will see you. So this is the process by which you can get an opportunity to enter into the premises during course of search. Next.
Yes, then tally jewelry with the valuation report, then they seal and seizure of jewelry and recording the Panchanama. Whatever they see, they make recording in the Panchanama. Whether siege or not, whatever jewelry is found, they make recording in the Panchanama. Next. Release of seized jewelry, normally by furnishing bank guarantee or after post-search assessment. If no outstanding demand is there, no proceeding is pending, then only can jewelry seize. Jewelry once seized can hardly be released excepting one provision, वो भी बहुत कॉमन नहीं है. ये जब तक आपकी डिमांड है, असेसमेंट पेंडिंग है, अपील पेंडिंग है, ज्वेलरी रिलीज नहीं होती है. और फ्रेंड्स, दे आर सर्टेन, इवन इफ डिमांड हैज बीन पेड, नो प्रोसीडिंग इज पेंडिंग, बट द डिपार्टमेंट इज वेरी रिलेक्टेंट इन रिलीजिंग द ज्वेलरी. 25 साल से ज्वेलरी वो लोग रिलीज नहीं करते हैं. नेक्स्ट. हाँ, नहीं, बैंक गारंटी कैन बी गिवन. आपको इक्वल अमाउंट की बैंक गारंटी में आपका इतना पैसा लग जाता है तो कोई देना नहीं चाहता है. पहले तो 25% में बैंक गारंटी बन जाती थी. नहीं, बाद में भी हो सकता है, पहले भी हो सकता है. आप कभी भी बैंक गारंटी देकर रिलीज कर सकते हो. Care to be taken during search. Since last 45 minutes, I'm talking about the search. I think the environment बन गया होगा सर्च का. आप लोगों को लग रहा होगा कि सर्च चल रही है. तो now just imagine कि search is started in the premises of your client or your. How you should tackle the officers on the spot. Officers are there to provide full hospitality to them. उनको पूरी हॉस्पिटलिटी दीजिए, कोई भी तरह की हॉस्पिटलिटी में कमी मत रखिए. प्रोवाइड फुल हॉस्पिटलिटी टू द ऑफिसर्स. जितना कि आप अपने वीवीआईपी गेस्ट को देते हैं, एज मच एज हॉस्पिटलिटी विच यू गिव टू योर वीवीआईपी गेस्ट, वीआईपी रिलेटिव, नॉट गेस्ट, वीवीआईपी रिलेटिव. Friends, can you tell me who is the VIP relative जिसको आप बहुत आदर सत्कार मान सम्मान करते हैं, हॉस्पिटलिटी देते हैं? बोलिए. दामाद. और किसने कहा? वाइफ के रिलेटिव. फ्रेंड्स, अब तो दामाद की कोई पूछ नहीं है. वो जमाना गया जब दामाद की पूछ होती थी. लड़की का ससुर, समधी और समधन, आई थिंक दे आर द मोस्ट वीआईपी रिलेटिव. वो जब आते हैं, हमारा 100% कंसंट्रेशन उनके लिए होता है. हम पूरी हॉस्पिटलिटी उनको देते हैं. तो आई जस्ट वांट टू कंपेयर, जिससे आप समझ सके कि किस लेवल की हॉस्पिटलिटी हमें देनी है. तो दैट इज व्हाट आई एम टेलिंग यू. प्रोवाइड फुल हॉस्पिटलिटी टू देम. एक्सटेंड फुल कोऑपरेशन. सम पीपल एक्सटेंड नॉन कोऑपरेशन. देयर शुड नॉट बी एनी नॉन कोऑपरेशन. You should always extend full cooperation to the search party. Non-cooperation is of no use. It rather irritates them और आपका काम खराब होता है. Not to be afraid of the threats by the officers. There are 2-3 common threats by the officers during search. They use these threats. Number 1, जो GST में भी बोल रहे थे, घिया साहब वगैरह, कि वी विल अरेस्ट यू. ये बहुत कॉमन थ्रेट है. वी विल बीट यू. नाइदर दे हैव पावर टू अरेस्ट. इनकम टैक्स एक्ट में कहीं भी किसी भी ऑफिसर को ऑन द स्पॉट अरेस्ट करने का कोई पावर नहीं है. सो दे कैन नॉट अरेस्ट नॉर दे कैन बीट. ये खाली थ्रेट्स के रूप में दे यूज जस्ट थ्रेट्स, एंड उस थ्रेट से उनका काम हो जाता है. The SSC get panic and make the disclosure or other confession. Huh? नहीं, creating obstruction is a criminal offense. Never. You make a complaint. बस अल्टीमेटली तो वही होगा ना, नहीं तो क्या आप करोगे? आप थोड़ी मारोगे उसको. You make a complaint. And if it really has been done and you are firm, he will be transferred or action can be taken against him. वीडियो में होता है, लेकिन उसके बाद भी हम लोग नहीं करते तो क्या उपाय हो? वीडियो होता है, विटनेसेज है, बहुत सी चीजें हैं। आपके ऑफिस में और भी 10 आदमी हैं, उनकी विटनेसेज है। नॉट टू रिमूव आर्टिकल और थिंग, कोई वहां से डूइंग कोर्स ऑफ सर्च, डोंट रिमूव एनीथिंग, इट इज एन ऑफेंस, क्रिमिनल ऑफेंस, एंड कॉल टू प्रॉपर एंड टू अवॉइड अननेसेसरी आर्गुमेंट। इसको क्लिक कीजिए, थोड़ा यहाँ क्लिक कीजिए, फोटो आएगा। वो ग्रीन को क्लिक कीजिए। हाँ हाँ ठीक है, अभी अभी जो है ना फोटो। हाँ, अवॉइड अननेसेसरी आर्गुमेंट्स। फ्रेंड्स, ये नीचे में कौन है? कैन यू सी? यंगस्टर्स बताइए कौन है? वो दिख रही है? किसी को दिख रही है? कौन? आप बोलिए, कौन है? हैं? करीना कपूर। और बड़ी खुशी है आपके चेहरे में। करीना कपूर और दीपिका, सर्च इज गोइंग ऑन। 2 दिन 3 दिन चलती है तो डेफिनेटली आप 50 तरह की उनसे बात करते हैं टू बिकम कंफर्टेबल, और उसी बात में यू कम टू नो दैट ऑफिसर इज फाउंड ऑफ फिल्म्स, तो आप फिल्म की बात चालू कर देते हैं, क्योंकि कंफर्ट लेवल कैसे आएगा। और उसी दरमियान वो बोलता है कि ही इज फैन ऑफ दीपिका, ही इज वेरी मच फैन ऑफ दीपिका। और हमारे भाई साहब, क्या नाम है आपका? प्लीज। सिंह साहब। अब इनको करीना कपूर पसंद है, अब ये दीपिका की बड़ाई क्यों सुने? ये आर्गुमेंट कर लिए कि सर क्या बात बोलते हैं, दीपिका तो आउटडेटेड है, करीना जैसी कोई हीरो नहीं है, और बात में आर्गुमेंट्स हो गए। तो अवॉइड दीज टाइप ऑफ अननेसेसरी आर्गुमेंट्स ड्यूरिंग कोर्स ऑफ सर्च। सिंह साहब, आपको ना तो दीपिका मिलनी है ना करीना मिलनी है उस दिन। So unnecessary, why do you make the arguments? The unnecessary arguments always we should avoid. There is no use, there is only harm. Next. Right and duties of persons doing search operations: to see search warrant, to verify identity of search party, to extend cooperation to search party, to have the facility of having meals and proper sleep. They will allow you to sleep, they will allow you to meal, they cannot object, they will do their duty. They can allow your children to go to school, they can allow the doctors to come. Next. Yes. क्या चीज है? नहीं, सर्च वारंट आपको साइन करके ले लेंगे वापस, नहीं उसकी कॉपी भी नहीं देंगे आपको। नो नो, दे विल नॉट अलाउ। फोटोज पे कॉपी दे देंगे ना आपको, दे विल जस्ट शो यू द सर्च वारंट, दे विल गेट इट साइन एंड दे विल टेक बैक। देखिए, स्टेटमेंट ऑन ओथ and statement at the commencement of the search, statement at the end of the search, and validity value of statement. तो स्टेटमेंट जो है वो ओथ पर लिया जाता है, और कमेंसमेंट ऑफ सर्च पर एक स्टेटमेंट होता है और बाद में एंड पर एक स्टेटमेंट होता है। स्टेटमेंट कैसे दिया जाए, क्या दिया जाए, ये एक बहुत ही प्रैक्टिकल चीज है, इसको फेस करना, क्योंकि स्टेटमेंट आपका सुप्रीम कोर्ट तक जाएगा कि आपने स्टेटमेंट में क्या कहा क्या नहीं कहा। अभी हो गया। आपका नाम? क्या नाम? क्या करते हैं? क्या क्वालिफिकेशन क्या आपके? सोच के बोल रहे ना, है एक्चुअली तो फिर कॉलेज में टाइम क्यों लग रहा है आपको? अरे आई एम आस्किंग यू द क्वेरीज, आई एम एन ऑफिसर एंड यू आर लाफिंग। मजाक है क्या? ये क्या करें आप? अभी ले जाएंगे बाहर आपको। आई एम नॉट पार्ट ऑफ स्कूचर। मैं खाली इसलिए आया हूं कि डिपार्टमेंट मेरे खबर कर सकूं। क्या करते हैं आप? प्रैक्टिस करते हैं। कितने क्लाइंट हैं? बहुत। जमा कैसे क्या करते होंगे? करते ना? स्टेटमेंट देना आपका। चलिए आइए। सॉरी, आई एम वेरी सॉरी फ्रेंड्स, this gentleman is knowing that he is in the seminar and I am speaker, but still इनका दोष नहीं है, he got nervous and he accepted that I am doing धमाका transaction before me। आप बताइए, इनकम टैक्स डिपार्टमेंट वाले ऑफिसर जब स्टेटमेंट लेंगे तब क्या हाल होगा? इसीलिए मैक्सिमम लोग जो कन्फेस कर लेते हैं वो ऐसी सिचुएशन बना देते हैं कि कन्फेशन हो जाता है। मेरे खाली जोरदार बोलने से ही उनको एडमिट करना पड़ गया। मैं तो खाली जोर से बोला हूं, वेरी क्वेश्चन जूरियस, मैं तो हाथ उठाया नहीं। इट इज नॉट क्वेश्चन, मेरी आदत है, आवाज जोर से निकलती है। देखिए ऐसा है जी, क्वेश्चन ड्यूरेस थ्रेट, मैं तो ये बोलता कि पुलिस को ले जाऊंगा तो बोलते थ्रेट दिया, मैं तो कुछ बोला ही नहीं ना। वो सब प्रूव करना हमारी ड्यूटी है। स्टेटमेंट थ्रेट में हुआ, क्वेश्चन में हुआ, वी हैव टू प्रूव। अनलेस वी फेल टू प्रूव, इट विल नॉट बी एक्सेप्टेड। देयर आर वेरियस केस लॉज, इट विल नॉट बी एक्सेप्टेड। यही तो प्रॉब्लम हो जाती है ना। देखिए, स्टेटमेंट एट द कमेंसमेंट ऑफ द सर्च, एक बहुत छोटा स्टेटमेंट, वेरी स्मॉल स्टेटमेंट इज रिकॉर्डेड एज सून एज दे एंटर इनटू द प्रेमाइसेस इन द रेसिडेंस एज वेल इन द ऑफिस। व्हेन दे एंटर इनटू द रेसिडेंस दे आस्क 2-3 क्वेश्चंस। हाउ मच कैश इज लाइंग इन द प्रेमाइसेस? मेरे क्वेश्चन को बहुत ध्यान से सुनिएगा प्लीज। हाउ मच कैश इज लाइंग इन द प्रेमाइसेस? द क्वेश्चन के रिप्लाई immediately the person whom the question is asked, he says 5 lakh, 7 lakh, 10 lakh, what it may be. This reply may be wrong. Because the question is how much cash is in the premises. There are other members in the family. Even the person may not be aware how much cash her wife is having. ये तो डिमोटाइजेशन मालूम पड़ी गया सबको। तो जब उसको अपनी वाइफ का ही पता नहीं है तो उसको अमाउंट कैसे पता है? ऑलवेज ही शुड से, सर आई एम पर्सनली हैविंग दिस मच कैश, एज वेल अदर फैमिली मेंबर्स आर कंसर्न, लेट मी आस्क, देन द रिप्लाई विल बी परफेक्ट। आर यू हैविंग बैंक लॉकर इन योर नेम? इफ दिस इज द क्वेश्चन, he can, if he is having a bank locker in his name, he can say yes. But if the locker is in the name of wife and the son, and locker is not in his name, he can say no, I don't have any bank locker. If afterwards it is found and the officer tells that why did you refuse, say you asked me for me, I don't have. So very tactfully the reply should be given depending on the question. चलो नेक्स्ट, चलो टाइम कितना है? हाउ मच टाइम इज गिवन? अरे बाप रे, इसीलिए पूछा हूं। चलो हो जाएगा। नेक्स्ट, नेक्स्ट हो गया स्टेटमेंट, तो बहुत हो गया। एट द एंड ऑफ द सर्च स्टेटमेंट में वाट एवर डॉक्यूमेंट्स आर सीज और फाउंड ट्रांजेक्शन इन द कंप्यूटर, उसको बड़े डिटेल्ड क्वेश्चन पूछते हैं। हंड्रेड्स एंड हंड्रेड्स क्वेश्चन दे आस्क इन द एंड ऑफ द स्टेटमेंट विच वी हैव टू एक्सप्लेन कि व्हाट इज द ट्रांजेक्शन एंड वट एवर द डॉक्यूमेंट्स आर सीज, उनका भी वो स्टेटमेंट में दे आस्क फॉर एवरी डॉक्यूमेंट बीइंग सीज। नेक्स्ट, चलो आगे चलो, एक मिनट पैक। Recording of confession statement is forcefully is not permitted. Government from time to time CBD issues circular, but the department is doing it their own. These are the circular where they have said that no conference statement to be elicited. Next. Guidelines during recording of statement. When the statement is recorded, what care we should take? To answer all the question to the best of our knowledge. Half-hearted question मत करिए. जो question में आप sure हो जवाब वही दीजिए. Not to refuse answer a question. Don't say I will not reply. Penalty लग जाएगी लंबी. To make reply after understanding the question. To reply in brief and with full confidence as soon as the question is asked. Sometimes what happens, even if the half question is asked, question पूरा नहीं होता, before that we understand what is the reply and we just give the reply. It should not be our habit. We should listen the question, even we understand what will the reply, but let him finish the question. We should listen it carefully, then there should be a pause, we should wait for half a minute, then we should reply. Because there may be certain question which you may require time to reply. So if it is the habit, then every question you get sufficient time to reply. To reply brief, to not to give false statement, never give a false statement, not to provide false and wrong evidence, to sign the statement recorded. Next. आगे. Next. एक minute. Before this, one thing. And reply should be given very humbly, politely. But suppose you are not knowing the reply of some question, or you want to avoid to give reply of some question, then there are two sentences which you can use from time to time, not frequently. That is, I do not know, I do not remember. These two reply sometimes you can use. But be careful. A question was asked to a person, what is your father's name? He said, I do not know. It should not be like that. And in one case, after the search was over, after 2-3 days, I took my client to the senior officer. It is the system, it is the practice. And likewise, I just told him to be very humble, very polite, or give very brief reply. What I am delivering here, I do not know how you will acquire it. मैं डिलीवरी अपने हिसाब से कर रहा हूँ, लेकिन आप उसको कैसे लेंगे, I do not know. The same thing happened there. The additional director asked him around 10-12 questions, one by one. He just told, मुंह नीचे करके, yes sir, yes sir. For every question he replied yes sir. The officer was irritated. कि उसने तो सोच लिया कि पाई जी ने कहा हम्बल हो जाओ और ब्रीफ कह दो, तो मैं हम्बल भी हो गया, ब्रीफ भी हूँ. And he was so irritated. The last question he said, am I a fool? He said, yes sir. It is a fact, friend. He got so angry. It took lot of time to just make him cool and make him understood कि सर देखिए वो नर्वस है तो हर क्वेश्चन का जवाब ही यस सर दे रहे हो, तो सुन ही नहीं रहे आप क्या बोल रहे हो. Then he understood. तो हम्बल होने में भी ध्यान रखिए, इतना हम्बल मत हो जाइए कि गेम्बल खेलना पड़े. The statement given can be retracted. They are Supreme Court judgments. According to it, the retraction can be made. Next. Statement may be under threat and caution, no corroborative evidences. Suppose a disclosure made that 20 crore rupees income is undisclosed, but no documentary evidence is there, it can be retracted. Such statement has no value. A statement in odd hours. A statement cannot be recorded in midnight, in odd hours. If it is so, it can be retracted. It is meaningless. Time limit for retraction and it should be as early as possible. Retraction should be as early as possible. And if by mistake you have replied something, you can retract that part with evidence that yes, it was by mistake, but the facts is like this. Next.
What is the mode of retraction? What is the mode of retraction?
Mode of?
Retraction. How to retract?
There should be affidavit, better against before a first class magistrate, and as early means within 2, 3, 4, 5 days, it should be filed before the DDI. But normally, we don't advise to file before DDI because then again a fresh statement will be taken and there can be 2, 3 DDIs. So it is really a matter of problem, but this is the system. I can advise one thing, I don't say that it is a full proof advice, but it can, you just file 3, 4 letters for Xerox copy of the statement to be given by the DDI. Normally, copy of the statement is not given by DDI. It is given at the time of assessment. And then you will not give the copy, you just give the reminder so you can show. And when the file goes for the assessment, you keep the retraction ready. As soon as you get the notice, you file a letter for giving you the copy of the statement. The AO will immediately give the copy of the statement. As soon as the AO gives the copy of the statement, you next day file the retraction. Now you can say that since you did not get the copy of the statement and you do not know what was asked to you, you just signed the statement. So without getting the copy of the statement, how could you retract earlier? So it can save you. Next, these are the case laws for threat and coercion, corroborative evidences, statement in odd hours. These are the case laws. चलो भैया आगे चलो. Time limit and by mistake. Next. Consequences for retraction of statement, really harsh. DDI will also treat very harshly and AO will also. Next, they can inform to the other agencies also if documents are found. Next. ये देखिए आपने कहा ना affidavit, mode of statement, petition, filing of return also 10 times to retraction of statement. Yes, and you can also ask for the cross examination if the statement of other persons are there during course of assessment. Next. Disclosure of income. 5 मिनट है तो भी तब ठीक है 5 मिनट गेस अगर हो गया तो मैं I will try to finish. Up to 31st March 2021 and after 31st March 21, there is a difference. Up to 31st March 21, the prime object of the department was to get disclosure. But after 21, in some of the cases or in most of the cases, they are not pressing for the disclosure. Although in certain cases they are pressing, but not all the DDIs are pressing for the disclosure. But now the search and seizure is a curse. आज से कई साल पहले जब सर्च होती थी, we used to tell that the group will prosper now. But now it is not so. Because of various amendments being made. Settlement Commission has been abolished. Then 150A and 150C has been withdrawn. Because in the completed assessments, if the addition had been made without any incriminating document being found, so that was deleted. And the matter was settled by the Supreme Court recently. And there were various High Court judgments. तो normally client लोग बच जाते थे. Regular book से कोई भी addition होता तो निकल जाता था. But now that is gone. Now there is 148 only. And in 148 they can go for the regular books of accounts like loans, share capital, etc. in guise of account entries. So now it's very difficult whether any document is found or not. But if the department insists for the disclosure on the basis of regular books of accounts for share capital, loans, etc., under no circumstance you should accept. You ask your client to accept. यही तो एक दिन 2 दिन बैठने दीजिए. Because matter, prosecution may be initiated. Or if prosecution is initiated, why if, mostly in all the cases they are initiating the prosecution, 148 के बाद में prosecution initiate होना ही होना. And if there is a confession by the SSC, तो कोर्ट में कोई चांस ही नहीं बचता है escape होने का. But if there is no confession, कोर्ट के कोई रास्ता निकल सकता है. इसलिए कभी भी अब एक्सेप्टेंस डिस्क्लोजर का होना ही नहीं चाहिए एट एनी कॉस्ट. नेक्स्ट नेक्स्ट There are penalties under various sections 278, 271D, 271E, 271AA और 271AAD. There are various penalties. Time short है, मैं इसको डिटेल में डील नहीं करा, but I will just deal 271AAD. Although it is not connected with the search and seizure, but the department can connect it with search and seizure because it is only 2-3 years old provision. As per this section, if any wrong transaction, false transaction is found in the books of accounts, then penalty to the extent of the amount of that transaction or that document will be imposed. Previously, suppose a bill of 1 crore rupees was found, sale bill, then what was happened? Normally GP was estimated 3-4-5%. और जीपी का भी 30% टैक्स बहुत स्मॉल अमाउंट हो जाता था. बट नाउ इफ वी प्रूव दैट इट इज ए फॉल्स बिल और बिल फ्रॉम एनी एकोमोडेशन नेचर, देन वो 1-1.5 लाख का जो टैक्स लगना है वो तो लगना ही है. बट 1 करोड़ रुपीज का अगर बिल है तो 1 करोड़ पेनल्टी विल बी इम्पोज. और इन सर्च आल्सो दे विल इम्पोज दीज पेनल्टीज नाउ. तो सर्च कितनी डेंजरस हो गया, अब सर्च को बचना बहुत मुश्किल है. फेक बिलिंग, हाँ वही मैंने कहा जीएसटी में भी ऐसा सिमिलर प्रोविजन है. एकदम जीएसटी वाले इन्फॉर्म नहीं, अगर जीएसटी इन्फॉर्म करती है इनकम टैक्स को, इनकम टैक्स आल्सो फाइंड्स इट फेक, तो वहां तो लगेगी और यहाँ फिर लगेगी, आपको यहाँ फिर पेनल्टी लगेगी. नेक्स्ट नहीं, वो पेनल्टी अलग है, वो तो आपका कंसीलमेंट का जो है अनडिस्क्लोज इनकम का उसकी पेनल्टी है. ये ओवर एंड अबव वो पेनल्टी भी लगनी है आपको. ओवर एंड अबव दैट पेनल्टी जो ये आपने रॉन्ग ट्रांजैक्शन फॉल्स ट्रांजैक्शन बुक्स में किया है उसके लिए अलग से पेनल्टी है. माने एक ट्रांजैक्शन के लिए कितनी पेनल्टी हो जाएगी, कोई हिसाब ही नहीं है. कंक्लूडिंग सजेशन, चेयरमैन साहब भी कंक्लूड करने के लिए बोल दिए हैं, सो आई एम जस्ट कमिंग टू द कंक्लूजन. बहुत फास्ट कवर करने की चेष्टा की है. रूमर्स एंड लैक ऑफ नॉलेज. नॉर्मली वेन एवर सच टेक प्लेस देयर आर लॉट ऑफ रूमर्स एंड वी बिलीव ऑन दोज रूमर्स बिकॉज ऑफ लैक ऑफ नॉलेज. तो सर्च के दिन इवन इन कलकत्ता सब बहुत लोगों को मालूम पड़ जाता है कि आज सर्च है, तो राउरकेला तो छोटी जगह, डेफिनेटली यहाँ एक सर्च होती है, सबको पता पड़ जाएगा. तो रूमर्स पर ध्यान मत दीजिए उस दिन. Don't give any attention on the rumors. मेरे पास में जब भी सर्च होती है तो सीए लोग के, एडवोकेट लोग के फोन आते रहते हैं. तो कई बार सीए आते पूछते हैं कि आज मेरे क्लाइंट के यहाँ सर्च हो गई. मैंने कहा हाउ डू नो कि टुडे देयर इज अ सर्च. तो बोले हमने सुना है, सुनी हुई बात क्योंकि तो गया नहीं है. तो मैंने सुना है कि ऑफिस, ब्रांच और फैक्ट्री सब जगह है. और मैंने पूछा घर पर है, बोला नहीं. तो इफ देयर नो सर्च इन द रेसिडेंस, देयर वेरी लिटिल चांस कि वो सर्च हुई होगी. देयर मे बी सर्वे. समटाइम्स द सी आस्क और द एडवोकेट आस्क कि सर मेरे क्लाइंट के सर्च हो गई है. अच्छा, हाउ डू नो? ही सेज बहुत आदमी है. Then I say, कितने आदमी हैं? The number of persons doesn't mean that it is a search. Even in the survey, if the place is big, there can be a huge number of persons. तो इस तरह की कभी कहते हैं कि दिल्ली से चार्टर प्लेन आया है, 300 आदमी आए वहां से, सब गलत है. Never. Now one change has taken place. पहले अगर दूसरी जगह सर्च आता तो 1-2 ऑफिसर आते थे, बट इन पॉलिटिकल सर्चेज अभी 1 साल में एक चेंज आया कि सपोज एनी सर्च टेक प्लेस इन कलकत्ता, एनी पॉलिटिकल सर्च, तो उसमें वो हैदराबाद से, बम्बई से, वहाँ से टीम ले आते हैं, बट ओनली बिकॉज की लोकल इन्फ्लुएंस को लेके, अदरवाइज लोकल टीम ही काम करेगी, बाहर से नहीं आते हैं। पर्सनल डायरीज, हाँ हो सकता है, बहुत से लोगों को पर्सनल डायरी लिखने का शौक है। ये दिस हॉबी कैन बी डेंजरस बिकॉज इन पर्सनल डायरी इमोशनली, सेंटिमेंटली वी राइट एनीथिंग। हो सकता है कि हम ये लिखें, हमारे कच्चे पक्के का हिसाब भी लिख दें उसमें, हो सकता है कि हम घर वालों के बारे में कुछ लिख दें, और एक्स्ट्रा मार्शलेशन की जो बात कही वो लिख दें, तो कुछ भी लिखा मिल गया तो पर्सनल डायरी उनके हाथ में आने से बहुत बड़ी तकलीफ हो सकती है, क्योंकि वन सर्च इज देयर, एवरीथिंग इज ट्रांसफर्ड टू देम, यू कांट हाइड एनीथिंग। तो पर्सनल डायरी मत लिखिए, और लिखें तो उसको घर में मत रखिए। लैंडिंग ऑफ इलेक्ट्रॉनिक डिवाइसेज, इफ योर फ्रेंड्स आस्क यू फॉर योर लैपटॉप, यू डोंट नो कि वो उसमें क्या काम करेगा। अगर वो मान लीजिए अपना अनअकाउंटेड हिसाब उसमें कर दिया और आपको लैपटॉप वापस दे दिया, और 1-2 साल बाद में कोई सर्च हो गई, इफ दैट अकाउंट इज फाउंड, वो आप पर टैक्स लग जाएगा, बिकॉज यू कैन नॉट प्रूव कि उसको बिलोंग करता है। इट इज बेटर गिफ्ट हिम ए लैपटॉप, डोंट गिव, इट इज बेटर टू गिफ्ट हिम ए लैपटॉप, डोंट लेंड हिम। एंड accommodation entries are the main reason for the search. It should be avoided. अब जितने भी प्रोविजन है, ऑल आर अगेंस्ट द accommodation entries, और अब फंसने के बाद निकलने का कोई चांस नहीं है। सो एडवाइज योर क्लाइंट नॉट टू गो फॉर accommodation entry transactions. Friends, I have tried to explain or share my experience honestly. Whatever I knew, I have tried to share with you in this limited time, and I am thankful to you for patient hearing. हाँ, क्वेश्चन तो डेफिनेटली।
Stop the normal business of the.
सुनाई नहीं दे रहा, जोर से।
मैं बोल रहा हूँ कि नॉर्मल बिजनेस क्या बंद कर सकते हैं, जैसे रिटेल शॉप चल रहा है।
देखिए, एज पर इंस्ट्रक्शंस आर कंसर्न, दे आर इंस्ट्रक्टेड नॉट टू क्लोज द बिजनेस। बिजनेस टू रन, फैक्ट्री वगैरह प्राय रन करती है, फैक्ट्री बंद नहीं होती है, बट ऑफिस में जब वो कंप्यूटर पर बैठ जाते हैं, सारा कंप्यूटर का काम करते हैं, तो बिजनेस ऑटोमेटिकली हम ही लोग बंद कर देते हैं, बंद हो ही जाता है। रिटेल में भी नॉर्मली जब बाहर के आदमी आ गए, सारा एक्शन हो रहा है, तो आपका बिजनेस ऐसे ही बंद हो जाता है। बट इनको इंस्ट्रक्शन, जैसे फैक्ट्री है, फैक्ट्री की ऑफिस में मान लीजिए सर्च चल रही है, फैक्ट्री चल रही है, फैक्ट्री वो बंद करने नहीं कहते हैं कभी भी। नियम भी यही है कि दे कैन नॉट आस्क यू टू क्लोज द बिजनेस। एनी क्वेश्चन? देखिए, ये सब बचकानी बातें हैं जी, इस सब में कोई आनी जानी नहीं है, ये सब बचकानी बातें हैं। इसमें कोई आनी जानी है। वन थिंग आई फॉरगॉट टू एक्सप्लेन, जो मैं कवर कर रहा हूँ, सॉरी, व्हेन आई वर टॉकिंग अबाउट द ज्वेलरी, तो एक सर्कुलर है CBDT का, बहुत इंपॉर्टेंट सर्कुलर है, एंड एज पर दैट सर्कुलर एवरी मैरिड लेडी, आप ध्यान से सुनिएगा, every married lady 500 gram gold jewelry, 250 gram every unmarried lady, and 100 gram every male. उतना अगर आपके यहाँ ज्वेलरी मिलती है, डिपेंडिंग ऑन नंबर ऑफ पर्सन जितने भी, उससे आप कैलकुलेट कर लो, तो उतनी ज्वेलरी कभी भी सीज नहीं कर सकते हैं. दिस इज CBT सर्कुलर. मेल को सिर्फ 100 ग्राम. डिस्क्रिमिनेशन है. और इसमें एक क्वेश्चन आपका आ सकता है कि व्हाट अबाउट डायमंड ज्वेलरी. एक क्वेश्चन है व्हाट अबाउट डायमंड ज्वेलरी. नथिंग इज मेंशन इन द सर्कुलर अबाउट द डायमंड ज्वेलरी, बट as practiced, if the diamond jewelry is found, then and the value of the diamond jewelry is up to the value of 500 gram or whatever gold jewelry there, normally they don't see their religion, but it is the discretion of the officer.
I think,
friends, I normally give this my presentation in various business houses, and there are so many secret things which I cannot share publicly. Although मैंने काफ़ी कुछ बताया वो भी नहीं बताना चाहिए, but there are so many things to face the search, and I've written a book on search and seizure, practical aspects of search and seizure. It is on question and answer.
May I have Session Chairman, Advocate Uttam Kumar Behra, to please give his concluding remarks.
What a wonderful, what a wonderful speech, sir. It was informative, educative, entertaining, and all put together in one basket. It is highly informative, and you also guided us the delicacies and the sensitivity of a search in the practical aspect, starting from be careful about your pen drives, be careful about your wives. Both the things one has to maintain during a search and seizure. Thank you, sir. We look forward to your next deliberation in future. Thank you so much, sir.
Thank you once again. We will now have the felicitation of our Session Chairman and Session Speaker. May I please request Advocate P.N. Bissy to please felicitate Advocate Uttam Kumar Behra. Advocate P.N. Bissy to please come to the dais to felicitate Advocate Uttam Kumar Behra. Ladies and gentlemen, please give a big hand for the felicitation ceremony of Advocate Uttam Kumar Behra. He is being presented a shawl and a memento by Advocate P.N. Bissy. Thank you so much. May I now request Advocate P.K. Raut, sir, to please come up and felicitate Advocate Paras Kocher. Advocate P.K. Raut, sir. Advocate Pavitra Pradhan to please come up. Advocate Pavitra Pradhan, sir, to please come up to felicitate Advocate Paras Kocher. Ladies and gentlemen, please give a big hand for Advocate Paras Kocher. He is being presented with a shawl and a memento. Thank you so much, sir, for such an informative session. May I now invite Conference Secretary Advocate Prashanta Kumar Prusti. I would like to invite Advocate Prashanta Kumar Prusti to please propose the vote of thanks. May I please invite Advocate Prashant Kumar Prusty, ladies and gentlemen, to propose the vote of thanks.
जय जगन्नाथ। आज सवेरे जब सेशन शुरू हुआ हमको लगा कि राउरकेला टैक्स बार का बेंगलुरु के साथ कुछ अच्छा कनेक्शन है। कनेक्शन इन द सेंस अभी वहाँ पे चंद्रयान थी, अभी उतर के 2 दिन हुआ लैंडर रोवर निकला है और हम लोग का यहाँ पे कॉन्फ्रेंस हो रहा है। इसका मतलब देयर इज कुछ गठजोड़, अच्छे गठजोड़ है विथ इसरो। पहली सेशन में भी हम लोग का वही सर्च एंड सीजर जीएसटी में चला। वी आर वेरी कॉन्फिडेंट। बहुत मज़ा आया क्योंकि साहब ने बोले कि यार कुछ नहीं कर सकते उन लोग। कुछ सबका सर्च एंड सीजर सुनने के बाद हम लोग काफ़ी डरावना हो गए। ये भी सोचने लगे यार अभी घर में फ़ोन करके तो क्या बता दूं, क्या चीज़ कहाँ पे रखे हो, क्या क्योंकि सेशन भी ऐसे ही चल रहा है कि एवरीबडी वी आर अफ्रेड टोटली। व्हाई टू टॉक अबाउट क्लाइंट्स इटसेल्फ। Anyway, this was a very informative session. Thank you, sir. So for this knowledge that is parted with us, and thank you, Uttam bhai, and thank you all to all my members. Thank you. Bye bye.
Thank you so much. Thank you so much, sir. I extend my hearty thanks to all delegates and special invitees who have attended the first day of this 2-day conference. I request all delegates to please sign and take their souvenirs. And I also make an announcement for the musical program and dinner from 7 p.m. onwards. Thank you so much. Thank you for coming.
Hello. I will request all the delegates. होटल पहाड़ी के बोर्ड रूम में ईस्ट जोन की मीटिंग चल रही है। होटल पहाड़ी के बोर्ड रूम में ईस्ट जोन की मीटिंग चल रही है। जो ईस्ट जोन मेंबर है वो होटल पहाड़ी के बोर्ड रूम में जा सकते हैं प्लीज़। एंड जो लोग सोविनियर नहीं लिए हैं वो लोग काइंडली बाहर काउंटर पे सिग्नेचर करके अपना सोविनियर ले लें। थैंक यू।